I just got early meeting today. You good? Okay, we'll get started. I'm JD Solomon, Chair of the Environmental Management Commission. I'll call the September meeting of the EMC to order at this time. I'll read the conflict of interest statute first. North Carolina General Statute 138A-15 mandates at the beginning of any meeting of a board, the chair shall remind all members of their duty to avoid conflicts of interest under this subchapter. The chair shall also inquire as to whether there's any known conflict of interest with respect to the matters before the commission. Looking around the room, I'm not seeing any yes, and I've not been pre-informed, so we're going to assume no conflicts of interest. We do have a quorum today, Counselor, I believe. Commissioner Gibson missed yesterday with a sick. There she is. Man, that was quick. Welcome. That was good. I waited just a few minutes and then you saw your email. So good to have you. So I think we have a full commission today. And with that, we are repopulated after all the new appointments as happens. I think for the public's sake and maybe for commission's sake too, we have 5 of our 15 members are now new members. And so that requires a little bit of transition. I think 2 years ago, we had 7 of 15 that were new. That's unusual. Usually it's 2 or 3 out of 15. One thing that we started, and I mentioned to the new members, we started that when I was chair the first time with Sheila Holman. Her and I did an orientation, and we've repeated that a couple years ago. I will plan to do that again in November or December for new members. I think that's been very effective in getting people started up. I'll have a few comments at the end of today, basically just things about emails and conversations just to make sure you're all apprised of that. I think most of you have talked to, so you're aware of that, but I'll repeat a few things for the public's sake. I want to go around the room and we'll do alphabetical order. Dr. Chmielewski, I think you go first. Welcome. And anything you want to say or about yourself or fellow commissioners or the public?
I'm here as a physician member of the commission and very honored to be selected to serve and looking forward to learning a lot on this commission. Yeah.
Very good. Dr. Jaspers.
Sure.
Oh, I just skipped. Diane Hardison, Commissioner Hardison.
Oh, that's right.
Let's you go first.
Good morning. I'd just like to say that I'm humbled and honored with this opportunity to serve North Carolina. And I look forward to learning a lot as well. Thank you.
Okay. Let's go to just brief background. Dr. Chmielewski, what's a little bit, just a nutshell thumbprint of your background for the other commissioners?
Sure. So I did my medical training in family medicine and went to med school at Duke, residency at UNC, so I'm divided. But and then in my career, I've worked both in clinical primary care practice in a rural community health center, a college health center, and kind of interwoven that with environmental public health work. So I've been a state employee in the Division of Public Health, most recently working on childhood lead poisoning prevention as a part-time consultant to that program in children's environmental health. And most recently worked at the EPA in clinical research focused on air pollution and health effects.
Okay. Commissioner Hardison, I didn't get your background just for everybody else's sake around the table. Anything you want to say about your history?
I'm an NC State graduate. Went from there to work in industry for the forest products industry and did that for 35 years as an environmental manager. So my background is really in the regulated community and navigating the regulations.
And you're familiar with a few of the staff here too, I guess, for that
Yes,
35 years. So
yes,
I would think
yes.
so. Okay, Dr. Jaspers.
Yes, Alona Jaspers. My background is in environmental health sciences. I worked at UNC for 27 years doing research on air pollution health effects and toxicology. And I'm just really excited to be here and serve for the people of North Carolina. So really excited to be here.
Great to have you. Dr. Zavaleta, I think you're next.
Hi, everyone. Yeah, I'm Jennifer Zavaleta, and I'm also very happy to be here. I retired from EPA in 2021 after 40 years. I started as a student intern, so I used to tease people that I started when I was 3. But as a student intern, and I'm also an import to North Carolina. I grew up in Ohio, spent time in DC, Northern Virginia. I've lived here in this area twice, and I was also out in Oregon for about 6 years. My background really covers kind of the intersection between human health and environmental health, in interests in toxicology, wildlife science, and public health. And for a lot of my career, I worked in the areas of water and the TSCA program, but a lot of my career was in research and development. And when I retired, I was the senior career lead for EPA's Office of Research and Development. And we covered research on all facets of air quality, water quality, chemicals, land, and then from all kinds of interests. So anyway, happy to be here.
Very good. And Commissioner Wright, I know you said some stuff last time when you were sworn in. Is anything you want to add today or any comments today? Or you've done your duty?
Good morning, everyone. I'm excited to serve with you. Welcome on board. And I say that as if I'm have a long tenure here, but I don't. So this is my second meeting, but I am looking forward to serving with you.
Do you feel better at your second meeting than you did your first?
Much.
Okay. I've told everybody it takes 2 or 3 to really get your legs underneath you. But anyway, it's great to have everybody and congratulate each and every one of you. I've always told new members this, is that the great thing about this commission is that there's no weaklings here. You guys have made it. There's 15 people here out of over 10 million. And somehow you guys have made it to the top of the heap. And when you look at all the people on this commission, everybody here is accomplished. Anybody here can take on the subject matter. They've got the range to be an all-terrain vehicle. Most of us have served on other boards and commissions before. Most of us have been in senior management roles before. Most of us have been part of the regulatory process before. We will have a good split of scientists and lawyers and engineers here. I just add that sometimes, your family and your friends are very proud of you because you're one of 15. The humble side of that is you're one of 15. And we can't really do anything as an individual here. It's got to be as a body. And so what we strive to do is find that consensus that's good for the environment, that's good for the social costs and benefits. That's our legislative charge. And third is our economic costs and benefits. So it's a little different for some of you that look at it under one lens. Statutorily, we have to look under all 3 lenses: environmental impact, social costs and benefits, and economic costs and benefits. As part of the process that we'll do, while we're all important, we will sieve things out and send it to public. And just in every environmental regulation, that's the key piece of this, that it has to go to the public to be consumed and get comments. And then we are charged with, when it comes back, to react to what those comments are and to get it right for the public involvement. When we make our votes, though, we're not all powerful either. It goes on to other processes, which means it goes to the Rules Review Commission to have one final check that what we're doing complies with state law. And if people don't think it complies to state law, then the General Assembly will take it up. So it seems like a powerful position on one hand when you're one of 15, but when you really look at it, you're just one of 15, and there's a lot of checks and balances on everything we do. So my goal as chair, we can go through that more, is to try to help this group work together and find the places we agree on. I've done this a long time now, so what my experience is, we agree on much more than we disagree on. And so if we can move those things forward and make incremental progress and do the right thing for the environment and the people, then we've met our goals, and we'll go from there. With that said, I'm gonna stop there. Any other questions or comments from other members around the table? I know we have new members. Commissioner Bailey, you've been here a long time as well and been involved in this process. Anything you want to add, or you're Commissioner Bumgarner at this point?
I'll just say welcome. I'm looking forward to working with everyone. And I agree, we have a really good group of people here with great qualifications, and we get to see all different aspects of issues with the people that are here and their backgrounds.
Mr. Bumgarner, anything to add?
No, nothing to add, just welcome.
Mr. Ellison?
I suppressed a chortle when you said congratulations.
I understand.
But welcome. Looking forward to working with all of you.
It's more work than you ever imagined, isn't it? A lot of reading, isn't it? Go to Bill. Bill, Commissioner Yarborough, anything you want to add?
No, just welcome. Look forward to working with you.
Mr. Tweedy?
Yeah, just welcome. You said, what, a few meetings to get your legs under you? I've been here 2 years and I still feel like I'm trying to get my legs under.
Yeah.
Good luck.
Very good. Commissioner Smith?
Keeping my powder dry.
Okay, very good. Commissioner Gibson?
Welcome to everybody, and I'm happy to see some old colleagues among the new members as well.
Yeah. And we'll get the name tags uniform. We're going to call each other commissioners for the most part. We'll try to get the name. You don't have your doctor in front of yours. They have their doctors in front of some of theirs. So we'll make sure we get that uniform for everybody. Commissioner King?
Well, it's always exciting to come every other month and be a part of this. This is my the fourth four-year term. So it's been really fun thus far. It still continues to be fun for me. And it's a privilege and an honor to be on this board and to serve. It's just a great part of my journey. And I hope it is a great part of your journey as well as we do these things that are important for all of North Carolina. Thank you.
Vice Chair Reardon?
Well, thank you, Chairman. I do want to welcome all the new members as well. Joined last year. It was an interesting time. I hope your time is not quite as interesting as maybe some of the previous ones, but welcome aboard. I will say diversity of thought is a strength, and everybody bringing their perspective to this gives a perspective to this that really can make us make good decisions. So I think we got a great team here. That's it.
Council, anything I've forgotten to do? I'm good. Okay, thank you. Hearing no other comments, let's move on to the draft minutes. And I will say, we have used this opportunity once again to relook at how we're doing our minutes. We don't have our minutes ready today. To give the new members some reference, maybe the public too, the record, the official record is really the recording of this whole meeting. So this is all on tape. And when we do minutes, over the years, we've struggled with how expansive to make the minutes and how small to make the minutes. The minutes are now around 50 pages when you try to consolidate all this down into direct transcript. So Joe, as a relatively new vice chair, and I have kind of said, let's figure out a little bit better way to bring to y'all maybe 15 or 20 pages. Maybe 10 would be my ideal thing. I'm a business guy too. But we've not gotten everything consolidated down in a new format. So we'll bring those back in November from the previous meeting. Comments, questions on that? Okay. Well, hearing none, let's move to our action items. Item number 1 is 25-33, request approval for final agency determination reports for periodic review of rules in 2D and 2Q. And that's Ms. Burleson. Joelle.
Commissioners. Welcome, new commissioners. I'm Joelle Burleson with the Division of Air Quality. And I work in our planning section. Thank you. On slide 2 of a presentation today, which will be very brief, are acronyms available for reference. And I'm here today to tell you a little bit about our periodic review of existing rules and make a request of you. The general statutes in the Administrative Procedures Act and 150B 21.3A require that all rules in state rules be reviewed every 10 years. The initial determination reports is the first part of that process. And the reports for the Division of Air Quality rules, your rules, are found in your package. Our rules are found in 15A NCAC 02D, where we have our air pollution control requirements, and in 15A NCAC 02Q, where our air quality permit procedures are housed. As part of the initial determination report process, you as a body have determined that all of the rules are necessary versus unnecessary for purposes of taking them to public comment. We held a public comment period on those initial determination reports from May 20th to July 28th. And no comments were received on the classification of the rules at this time. So the final agency determination reports in your package categorize all the rules as necessary following the public comment period. In terms of the process that we undergo, we're here today to ask for your final approval of these reports and responses to comments. There are no responses to comments, as there were no comments. And we would plan to move forward if you choose to approve the reports as presented to you today, to provide them to the Rules Review Commission that Chair Solomon spoke to for the next step of the process. And we would do that by our November 20th deadline to submit the reports for the review by the Rules Review Commission at their December 18th meeting. Following that, in early 2026, we would expect to hear back from the next step in the process after the Rules Review Commission provides those reports to the Administrative Procedures Oversight Committee of the General Assembly, as to whether they have any adjustments or changes, or the reports will become final. After that, the next phase would be for us to work with the Rules Review Commission staff attorneys through the department rulemaking coordinator to establish a schedule for readoption of all of the air quality rules. And the first round of rule readoption many years ago, we received approximately a 4-year time frame. So we'll have to see what the commission at OAH decides this go round regarding that. Once that's done, we would then proceed through the normal rulemaking process on all of our rules to accept public comment, bring them back to you, and you to act on them. So at this point, present to you, the director recommends that the EMC approve the final agency determination reports for the periodic review of existing rules in 15A, NCAC, O2D, and O2Q to proceed to the Rules Review Commission.
So as Joelle mentioned, when we first did this, started it 10 years ago and went through the first round, there were 3 buckets. We call them buckets. We put the rules in buckets, and there were 3. Now there's only 2. The statute changed. This is all by statute. So the statute's changed. There's only necessary and unnecessary. So staff's looked at it, determined that all these rules are necessary. Basically, they came to us first and asked our opinion of some of that. They're asking us now to go to RRC for that. That went through the public process. The rulemaking readoption has officially started, I guess you could say, but the rulemaking, the modifications to the rules have not started. Now, rules review and readoption for new members is basically when you read the statutes, rules that laid around for 30, 40 years in some cases, and I can cite some of the ones. They had not been updated for citations, for definitions, for language, and even whether they were necessary or needed to be off the books. So the first time we did this was a major push to get all that cleaned up. I'll set as an aside, nothing in the rules review and readoption says we have to optimize a rule, improve a rule, make a rule better. It's really just to go back and make sure the rule is as current as it should be, and we think it's still applicable. Okay. A lot of times we will try to make the rule better because we don't want to go through this public process twice for minor things. But at its heart, if we can't agree on changes that need to be made beyond the citations and whatnot, we need to keep the schedule and keep the rules review going to keep that current with laws and other statutes. So that's really the purpose here. And what Joelle's really asking us to do is to say, we agree all these are necessary, take it to the RRC to set our schedule, and then they'll come back through our committee process, probably at the schedule she said, and we'll start the official rulemaking process to readopt. So I know that's confusing. That's a lot for new members, but without telling you how to vote, this is pretty procedural right here. And I think you'll have your bite of the apple in a few months when it comes back through the committee to really decide whether you want the rules improved or not. Okay, questions?
Question. Are we voting, I think you said every 4 years the rules would have to be reviewed?
No, ma'am. I think what I was trying to say was that when we went through the process last time, we had a 4-year period to get all of the rules readopted after we completed this report first phase. The rules under the statute have to be reviewed every 10 years per a schedule that the RRC sets in the North Carolina Code. So
Right.
Register.
It's the funny way, and you know, most of y'all know how rules work. It takes so long. We had a 10-year window to readopt them. But by the time you do the process, we just finished this 2 years ago, and now we're back. After 8 years, we're back reviewing the ones we started with before. So time goes slow in rulemaking sometimes, so. Good question. Yes, Mr. Hardison.
In reassessing whether rules were necessary or unnecessary, was there any consideration with the 2Q 0700 air toxic rules now that all of the federal NESHAPs are in place? Was there any consideration that this section of rules for air toxics may not be necessary any longer since it doubles, in some cases, more restrictive than the federal rules for NESHAPs?
Well, the air toxics rules that you're speaking of are actually on a different basis than the federal NESHAPs. And the NESHAPs started off with a MACT basis in the more recent standards, and then have the follow-up residual risk review. But the pollutants on the air toxics list and the pollutants on the federal HAP list are not all the same. So there's some that are North Carolina specific and some that are not. And so the look under the air toxics rule is what the concentration at the property boundary or beyond would be, whereas under the MAC standards, there's the control technology application aspect, and under the residual risk review, there's a review of whether or not, as I know you're familiar with, there is a risk that requires additional control or other measures under the federal program.
So there's a thought that the MACT standards, which are controlling many of the same compounds, were not sufficient for North Carolina.
There's that possibility in some cases, and there are also many sources that are not subject to a MAC standard. So there's that portion of population of sources that could also be subject to the state air toxics program.
Thank you.
So Ms. Burleson, I think, make sure I know what you're saying is it's kind of embedded in the current rules. So it wasn't a specific rule you thought you could pull out because it's not one for one, so to speak, with the federal rules at this point. Is that what we're kind of understanding at this point?
That is my current understanding.
Okay. And just remind commissioners, you can agree or disagree with that, but we will have a chance to come back once we get the RC schedule to actually go in and dissect each one of those rules and strike out the things we think are obsolete as well. This doesn't bind us to adopting everything in every rule, but we will have a chance to tweak it if we get under the hood and see certain things can go if it's the will of this whole commission. So that answer good for now? Any other follow-up? I know you're right off the bat. You're getting right in there, Commissioner Hardison. I like that.
I do have one other question.
Go ahead.
Not being overly familiar with the process for regulatory impact analysis, in the readoption process, when a rule is not federally required, only state required, is there a requirement to do a fiscal note?
Yes, ma'am. It doesn't, it's not based on whether the rule is federally or state required. When we go through the process, we still
For
have to do.
readoption.
That's my understanding, is that we still have to make an assessment and go through that process. It may not be an extensive fiscal note depending on the nature of the rule itself and its impacts.
To simplify and to clarify, I think if there's an existing rule in the books, the baseline is zero at that existing rule. So the fact is not questioning the cost of the rule that's in place because it's in place. It's the incremental part we add to it. So the fiscal notes, the regulatory impact analysis is really simple for most rule readoptions, unless we're asked to go back and go to the below the baseline. And that's defined in APA too, the Procedures Act and all that stuff. So your question is a good one that gets asked a lot, like why we got the rule there, and it is adding cost. But for our regulatory impact analysis, historically, we've used the baseline as the existing rules already there. So we'll have that debate again. We have it often, so we'll have that debate again, I'm sure. So,
Thank you.
you're welcome. Any other questions or comments? Okay, hearing none. We would have a here. Well, yeah. Committee chair. Oh, we don't have a committee chair. Don't have a vice chair right now. No, Commissioner Ellison, do you have a recommendation here? I don't know if you're on the committee, so you should have you have a commission. You want to make a motion to approve this?
I will make a motion that we move forward with the approving the final agency determination for the periodic review of 15 ANCAC 02D and 02Q and proceed to the Rules Review Commission.
Okay, do we have a second on the motion?
Second.
Commissioner King seconds. Any discussion on the motion? All in favor say aye.
Aye.
Any opposed? It's unanimous. Good.
Thank you.
New members, that was a softball one there. That was as easy as they get right there.
So we're done now? We're done?
Yeah. You call it that. For the public's sake too, and fellow commissioners, historically, what we've done, we've had new members is the chair appoints the committee assignments and chairs and vice chairs. What we've historically done is as we've added new members, they took the seats of the chair, the committees of the previous members that they replaced. We have done that again for everybody's benefit of knowledge. Now that we have a full commission back, I'll look back again at the committee chairs and interest and be talking to each of you to see if there's better alignment with that, because we want people aligned with where their expertise is. That said, don't get mad at the chair of the EMC, because one of the duties we have to do is make sure when it gets to the full commission, it's balanced. So some of you, and y'all have been exposed to it already, some existing commissioners, you get on committees that you don't know much about. But that's all part of the thing to make sure that the commission is cross-trained and cross-pollinated, whatnot. So, but we will try to get you on the committees you have the most interest in and the most excitement on. As you heard yesterday, you know, sometimes the Water Allocation Committee doesn't have a lot going on. If you get on the Water Allocation Committee for the next year or two, you're going to have a lot of action. So it's certain committees that have been active in the past are not as active, and certain ones that vice versa happen. So we'll work with our best to get you there. Okay. Next item on the action item is item 225-34, request approval for hearing officer's report and adoption of 15A NCAC 02B 0202 amended by session law 2023-63. And Sue Homewood will give our presentation. Sue, before you get started, will this be one of your last presentations to the EMC?
It will be my last presentation.
It
yes.
will be. Well, we've enjoyed having you for I won't say all these years. I don't want to date you.
It has been a long time.
Congratulations on your retirement that's soon to be. And thank you for all you've done to help this EMC out with your knowledge and information you've shared. So thank you.
Thank you. Good morning. I'm Sue Homewood with the Division of Water Resources, and I am presenting the hearing officer's report to implement Session Law 2023-63 to clarify the definition of wetlands. So in Session Law 2023-63, the General Assembly redefined wetlands in North Carolina as waters of the state being restricted to waters of the United States as defined in federal code. In Section 15D, the General Assembly mandated that the commission shall adopt a rule to amend the wetlands definition consistent with the session law. And that is the process we are hopefully concluding. So this is the definition that was in 15A NCAC 02B 0202. And the underlined portion is what was added to implement the session law. And that is strictly from the session law verbatim. Wetlands classified as waters of the state are restricted to waters of the US. Because the proposed amendments were required as part of the session law and the session law was effective immediately, then while we did a regulatory impact analysis, the baseline was the session law that was already in place. The division has been implementing this session law since it was passed. So the regulatory impact analysis was there was no change in adopting this rule from the session law. There was an initial regulatory impact analysis. The commission asked for some modifications. A revised regulatory impact analysis was approved by OSBM in December of 2024. So then we went through the process of requesting that the commission approve us to go out to public hearing. That hearing was held on June 26th of this year. It was a combined virtual and in-person hearing. We had a comment period from May 1st to June 30th. During that comment period, we received 13 oral comments at the hearing and 134 written comments. Of those 13 oral comments and 133 written comments were opposed to the rule amendment, and 1 written comment was in favor of the rule amendment. So the hearing officer's report, a large number of the comments were similar in nature. So we provided a summary and for ease of review. This is the list of the summary of comments. I'm not going to read these verbatim. In general, the comments opposed to the rule amendment were concerned about loss of wetland protection in North Carolina, what that means for flooding, resiliency, wildlife habitat. There was a concern that North Carolina wetland rules shouldn't be tied to federal wetland rules. We should focus on what's important for North Carolina. That we're spending a lot of investments in mitigation and flood resiliency, that these wetlands could help provide for that. There were some legal comments that the General Assembly should not dictate a rulemaking body on how to implement rules. All that is in the hearing officer's report. In general, the response to the comments is that the scope of the rule amendment was dictated by the session law. The session law mandated that the EMC amend the rule substantially similar to the language provided in the session law. So the hearing officer recommendation in the hearing officer report is based on that dictation from or mandate from the General Assembly. So here's the timeline, a little bit of the history. As I said, we had the session law in 2023. The EMC requested that we move forward with this rule amendment, even though we were implementing the rule and are implementing the session law already. So in January, we went to the Water Quality Committee and requested to proceed to the EMC. In March, we came to the EMC requesting to go out to public hearing. The rule was filed with OAH and placed in the public North Carolina Register. The public comment period started May 1st. We had our hearing on June 26th. I'm sorry, this slide has a typo in it. And then we are here at the EMC today. If the hearing officer is hearing officer's report is approved, we would submit this rule to OAH tomorrow. The effective date based on the session law is after the General Assembly has a chance to review it, which would be the 2026 session. And after that, it needs to be approved by EPA because this definition is part of our water quality standards. So here today, DWR requests that the Environmental Management Commission adopt the proposed amendment, 15A NCAC 02B 0202 definitions clarify the definition of wetlands pursuant to Session Law 2023-63. And I'm happy to answer any questions.
A couple comments before we go to the hearing officer and maybe back to Ms. Homewood for more questions. For new members, we are in the public, we are blessed, probably in my history and my knowledge, with 3 wetlands experts on this commission like we've never had before. Commissioner Bumgarner, Commissioner Ellison, Commissioner Tweedy. They do this for a living. 2 of them did it as directors of mitigation services for DEQ. So we have a vast knowledge of wetlands, and they were asked to initially come together and talk about this when it was first passed and what do we do about it, or what can we do about it. Bottom line kind of comes down to this. It really does come down to this. The state laws have got, Constitution has supremacy over the state laws has supremacy over our rules. And so we can't have a different nature of rule than what the state laws have, or in this case, it wouldn't apply to the Constitution. But our rules have got to be consistent with state laws. And so while this is a little unusual to say, let's just they did their action, we have to clean up our rules now to make sure the definitions fit. There's a lot of people with a lot of opinions about it. I think our 3 wetlands experts historically have opinions about it too, and not all agreeing with everything here. I won't say they disagree. I won't say they agree, but this is what we got. And this is what the state law says. And in a large way, This again is more or less procedural. And I know people will talk about it and they'll grandstand on it and they'll have concerns about it. But we've more or less got to comply with the state laws here. So with that, Commissioner Baumgartner, you've got a few words before we take questions for both of y'all.
Don't know that there's a whole lot more to say other than what you said. It was a statutory directive from the General Assembly. The hearing that we had, there were concerns of wetland loss, impacts to wetland function, funding, but this being a statutory directive, we're following APA, Administrative Procedures Act, and making this rule change. So we're just following that procedure to catch the rule up to the statutory directive. So beyond that, there's not really much more to add on my side.
Okay. Questions, commission members to Ms. Homewood or Ms. Hearing Officer Baumgartner? Yes, Commissioner Zavaleta.
Morning, and congratulations on your upcoming retirement. Sorry you have to do this one last. But so a question and a comment. Going from the public comments, has there been some kind of an analysis of the impact of those resources that would no longer be covered with this change?
The division has not conducted an analysis. The federal definition of waters of the U.S. is flexible, or not flexible, changing all the
Yes.
time.
Yes.
So it's really hard. It's a moving target.
Right.
And I think while there's federal language in rules and case law, the implementation on the ground is still an uncertain aspect of that. And so it's very difficult to identify exactly numbers. There are entities that have estimated based on all kinds of mapping resources and their understanding of case law, but I think it still remains to be seen exactly the final numbers.
Yeah, and that was going to be my comment. Having been around in the agency for the different views of waters of the U.S., it does seem to be a bit of a ping pong match that is constantly changing. So there is a fair degree of uncertainty here, which I think really puts the state in a difficult situation, especially as you look forward in implementation. And, so that to me is concerning. I understand that it's moot at this point. And so, this is a formality, but I think that there's a lot of concern with the fact that it's, back on the radar for the agency with this administration. And things that I've heard is that should there be a change, well, there will be a change at some point of administration in the next election, regardless of which party prevails. But, it's likely to come back up again. And people are saying, please do not re-debate waters of the U.S. So, well, it remains to be seen. But I do feel like it's really going to put the state in, in that flux of having to readopt, reanalyze, and the resources are going to be the ones that are at risk.
Okay. Questions or comments of Mr. Tweedy?
Just real quick, Zavaleta?
Orm Zavaleta. Jennifer responded.
I agree with your sentiments and just want to say, I hope that, I understand our path is set today, but I'm hoping there's some way in the future that we can disconnect what the state of North Carolina does from the Fed. North Carolina has unique resources that I think a lot of people, obviously from the comments, agree it should be protected. I think we can do that protection in a smart way that takes into account everybody's concerns and issues with wetlands. But I think connecting it to the Fed and keeping it that way is just not a good long-term policy. But second comment, if I may,
Sure, yes.
I want to thank Sue for her service. I think, Sue, I've known you my entire career. I think we've worked together on permits and stuff. And I've always seen you as a collaborator and not adversarial. So, and I've always appreciated your insights and working with us on projects. So congratulations on your retirement.
Thank you.
Yes, Commissioner Chmielewski.
I'm just, one thing I was curious about in reading the materials, I saw that the North Carolina Farm Bureau opposed this, and I was wondering, but I couldn't find their comment. Do you know what that opposition was?
I believe the Farm Bureau was the one comment in favor. Is that, okay.
Oh, no,
Farm Bureau was the one comment in support of this legislative, or this rule directive.
And I also just wanted to clarify and maybe hear from Commissioner Smith. My understanding is the state can choose to be more protective than federal regulations, but not less, correct? So.
If you'd like me to respond to that.
Yes,
that
please
is-
do. You were called out, so let's
That is
give your
correct.
opinion and we'll try to.
That is correct.
Yeah.
With some limitations in state law, there are some provisions in state law that say if there's, for example, a numerical standard for a particular pollutant at the federal level, we cannot exceed that type of limit. But otherwise, this particular issue, as we've talked about before, part of the reason this is very bad policy is that nothing going on at the federal level is about which or whether these wetlands are important for ecological or other purposes. The only issue at the federal level is federal jurisdiction. And that's driven by the Commerce Clause of the United States Constitution, and it's driven by the language of the Clean Water Act. It's a jurisdictional issue at the federal level. It has nothing to do with assessment of the value of these wetlands. So that, under the Clean Water Act, that is primarily a state responsibility, which is why, as others have said, it's a mistake to tie state decisions about the value and protection of wetlands to a federal jurisdictional issue.
Let me go back to, because that's exactly right. I just, two, you'll hear Hardison Amendment talked about at the state level for you guys that aren't the more federal or global type people. You'll hear Hardison Amendment, and that's specific to North Carolina about this regulatory thing. And it's debated. It's debated whether, where it applies and where it doesn't. I think Commissioner Smith is right, and that of course she's right, but she's an attorney and does this whole career. I think the hard part of the wetlands issue was how this one kind of unrolled from the beginning and got to where it got in the General Assembly. We had a state provision that protected isolated wetlands and bogs and things like that. The General Assembly in 2015 passed on anything to do with connecting wetlands. And so this whole debate got it started out of that third level, not riverine wetlands, not bogs and isolated wetlands, but they intentionally passed on that piece of it. So the question becomes, if they passed on it, then can we make a rule for it now? And that would have been another interesting legal debate. Instead, the General Assembly just came back and said, we're not going to deal with that. We're just going to say all of it. So for good or bad, we just came back and said, just stay with the Fed requirements, which is kind of the basis of the Hardison Amendment anyway, is staying with the Fed standards. And that's how we got here. So we are where we are, and we still have a statute on the books. It's been in place for 2 years, and we have to clean up the rules. But I agree with what Commissioner Smith just said. Commissioner Bailey.
Thank you. Well, I just want to say, at least I think I'm still the only one who lives on the coast. A lot of the comments were from people that live on the coast. It's very important to us there. So they oppose this rule change, but I think everybody understands that we're directed to do that by the General Assembly. So then my question is, since the session law expires when we enact this as a final rule, then what is in the statutes as the definition of waters of the state in the statute? Because our rule is going to say one thing. Because this statute expires.
I don't have it in front of me, but my recollection is the statute is broader and talks about any body of water. And then the rule is more specific in defining which of those bodies of waters are classified in O2B. So
in a way, the rule is more restrictive.
I'm not sure that I have the legal education to be that specific.
Yeah, I don't think so.
Mr. Chairman?
Yes, Mr. Smith.
I think that's a really good question, and we've talked about this a little bit before. And so aside from bad policy, it's bad legislative practice, because the part of this session law that's missing in the materials is the section E that causes this entire session law language to sunset as soon as this rule is adopted. So it goes away. What the legislature did not change, as Commissioner Bailey mentions, is there is a definition of waters of the state in statute that will continue to be in effect after this session law expires. And that definition says that waters shall mean any stream, river, creek, brook, run, canal, swamp, lake, sound, tidal estuary, bay, reservoir, waterway, wetlands, or any other body or accumulation of water, surface or underground, public or private, natural or artificial, which is contained within, flows through, or borders upon this state. That's the definition in GS 143-215.77. The legislature has not changed that. That will continue to be in effect. And so the chair is correct. Our rules can't be in conflict with state law, but unfortunately what the legislature has given us is a situation that will create a conflict with state law. I'm going to vote against approval of this rule. I understand the realities of the situation, but between the policy and the legislative process and the, in my view, misuse of a session law in this way without clarifying the statute makes this an easy vote against for me.
You have any? Yes.
So a question, if this group does not approve this, then what?
Session law is in effect and it'll just keep running until we clean it up. But we need to clean it up or the session law stays in effect. And they still enforce it as it's written right here.
So will it be Groundhog Day then, that this comes back if we say no? And we keep having to revisit this until we approve it, or?
Well, maybe, and I say maybe because we'd have to get clarification on that. The reality is, we normally would have done this by now.
Mhm.
And because of the debates on some of the language in the regulatory impact analysis, it's been 2 years in the making, and it might be 4 or 6 years before we come back and revisit the rules. So it's going to come back in one way or other to this commission is to make the rule match the statute. So, Commissioner Gibson.
Well, if the statute that's driving this change is going to expire and then the resulting new rule, if we pass it, will then be in conflict with the remaining statutes, is there an opportunity for somebody to go and request a change back to the old definition of wetlands? Is that a pathway?
There's probably not a restriction on that pathway. And we'll talk
Okay.
about petitions for private petitions for rulemaking in a little bit later, maybe not. But yes, any citizen in this state can make a petition to this commission to generate rulemaking. And that's also in the statutes and in our rules, how to handle that, and in our operating procedures. And so anything we do, the bottom line is it doesn't have to come from DEQ. DEQ is the regulatory agency. We're the rulemaking agency. The traditional path that comes through is DEQ to us, but anybody can bring a rule to us through that process to change any one of our 1,000 rules we've got, 900 some odd rules. Commissioner Baumgartner.
This is, the discussion on waters and in statute is really not, in my opinion, relevant to this discussion. But since we went there, that statutory language was set way before there were a lot of wetland and stream concerns in the state regulatory wise. It's way predates the mitigation rule from what I understand. So there has been a lot of regs that have applied to wetlands, streams, bogs since then. There's not been any statutory definition to define what waters is in the state further. There's no statutory definition for stream. There's no statutory definition for bogs. So even the waters definition in statute is not defined well enough for a practitioner to interpret and apply it. So, we're getting kind of wild debate here on something that is kind of ancillary to where we're here, but I'll just kind of leave that up here.
Commissioner Ellison, you had a comment? A question?
I have a question. back at the end of your timeline is EPA approval. Is that at the region level or Office of Water, or who does that, and how long does it take?
Thank you. Good morning, Karen Higgins, Water Planning Section. So because the definition is part of the standards, we send that to Region 4. It's up to EPA whether that decision's made at Region 4 with or without consulting with headquarters. They have 60 days to approve, 90 days to disapprove, but nothing happens if they take longer. We have had provisions up there that have taken longer than a year before getting a decision. So it's really kind of up to EPA to make that decision.
So historically, if there is a disapproval, does that come with recommendations to make it so that they would approve it?
Yeah, so if EPA disapproves a standards change, they send it back to the state. The state can resolve the disapproval and correct it per EPA, or EPA can promulgate rules for the state.
And if there's a correction necessary, that has to go all the way back through our rulemaking process.
It does.
Thank you.
But again, adding most things from EPA would be you're violating some other program or something at the federal level or some definition. In this case, back to what Commissioner brought, we are at the federal definition and we've followed our APA process, or we wouldn't be here as an EMC passing a rule. So while they can comment, it's probably a very limited chance they're going to have something on this particular one to say, throw it out because you violated some other statute or federal statute or rule, or you didn't follow your own process very well. So they could though, yes.
And my understanding is wetlands have a narrative standard. Their water quality standards.
Yes, I was trying to like think through all the parts of it that none of them are numeric. Yes, they are narrative.
All right, if no other questions, I'm going to ask Commissioner Hearing Officer to give a recommendation, a motion, please.
Mr. Chairman, I make a motion that that the EMC adopt the proposed amended 15A NCAC 02B 020 definition pursuant to Session Law 2023-63.
Okay, we have a motion. We have a second. Commissioner Ellison seconds. Discussion on the motion now. No discussion on the motion. All in favor, please say aye. Aye. Any opposed?
No.
No.
Okay, let's go. I think I heard Commissioner Smith, Commissioner Gibson, and Commissioner Jaspers in the negative.
No, and myself.
Okay, Commissioner Zavaleta.
Also Chilminski.
Oh, y'all got to speak up louder. We'll do hands next time. Chmielewski. You got that right? Chmielewski, Jaspers, Zavaleto, and Smith, and Gibson opposed. Okay, all in favor. Motion passes. Okay, let's move to our next item. Thank you, Ms. Homewood, and congratulations again. Item 3, 2535, request approval of hearing officer's report, regulatory impact analysis, and adoption of the rule for 15A NCAC 02L 0202 groundwater quality standards. And yes, Ms. Shelton will give that. Just making sure. Oh. Sorry, Bridget, let me go back. Let's amend that to do the regulatory impact analysis. I don't know that you read that. Did you read regulatory impact?
Motion that was on the screen, but yes, it needs to include that.
Okay, can you make a separate motion now on the previous item to get the regulatory impact? It may not have been on your agenda.
Yes.
Make a second motion to approve the RA.
I just say the motion.
Second motion to approve the RA.
Make a motion to approve the IRA to amend the previous motion.
Okay, we have a second. All right, discussion from the commission on that, just real quick, let me add this in. When we approve the rule language, the text, we also, by the APA, have to approve the regulatory impact analysis. Normally what I have for you commissioners and for the public, if you read the action item here, it should say all of that on it so that y'all can just read it, keep it simple. We all know what we're voting on and it comes to the record. This case, I don't think it said regulatory impact analysis as well, so we had to add that there. The issue you're just about to see in a minute has it in the text title. So hopefully in the future, we have the text title all right and the agenda item so you can just read from it and that'll be the motion. So you did read from it, Commissioner Baumgartner.
It just wasn't on
It just wasn't on there. So now we have a separate motion and a second on the previous item for approving the regulatory impact analysis. Any discussion on that motion? Hearing none, all in favor, please say aye.
Aye.
Same opposed?
No.
No? Commissioner Gibson?
I'm going to just abstain on this one.
You're opposed? Nope, you're put, okay, let's show hands. All in favor of the regulatory impact analysis, say aye.
Aye.
Okay, any opposed to regulatory impact analysis? We got one. Very good. That add up?
Yeah, thank you.
Okay, thank you. Sorry about that, folks. It's not perfect always, and thank you, Commissioner Baumgartner, for amending that for us, or separate motion. All right, now, Ms. Shelton.
Great,
your
thank
floor.
you. Good morning. I'm Bridget Shelton with the Classifications and Standards Branch in the Division of Water Resources. So I'm here today to request of the Commission approval of the hearing officer's report of proceedings, the regulatory impact analysis, and the adoption of the proposed rule amendments for 15A NCAC 02L 0202 groundwater quality standards to establish groundwater standards for 3 PFAS compounds. So for these proposed amendments, DEQ evaluated the available scientific data for PFAS compounds in order to develop groundwater standards for a subset of PFAS. These groundwater standards were developed in accordance with the procedures in the Rule 15A NCAC 02L 0202. The proposed amendments are the adoption of standards for 3 PFAS, and those are listed on the slide here. So those would be PFOA, PFOS, and HFPO dimer acid, otherwise known as GenX. The values of those standards are also shown on the slide here in units of nanograms per liter or parts per trillion. The other proposed amendment to the rule is an edit to the groundwater standards table header in the rule that states that the standards are listed in units of micrograms per liter unless otherwise indicated. So this is just to signify that other units of measurements may be listed in that table. So these proposed rule amendments are also included as attachment C for this item, and more information on the development of these standards is included in the appendix of attachment B for this item. So the EMC approved these proposed amendments and associated regulatory impact analysis to go out to public notice and comment at the September 2024 meeting. The announcement of the public comment period and the public hearings was published in the North Carolina Register on November 1st, 2024. The public comment period was from November 1st through December 31st of 2024. We held 3 public hearings across the state in November and December, as you can see here, one in Charlotte, one in Wilmington, and one in Raleigh. We have listed the registered attendees as well as those registered to speak at each hearing. So 10 registered to attend in Charlotte with 2 registered to speak, 56 attendees in Wilmington with 16 registered to speak, and 19 people attended in Raleigh with 6 registered to speak at that hearing. At the closing of the comment period on December 31st, we received 576 individual written comments. So these received comments are summarized and responses are provided in the hearing officer's report of proceedings, which is included as an attachment for this item. As a general overview, the majority of the comments that we received were in support of the 3 proposed groundwater standards. We did receive comments that covered topics of similar concern that we grouped together in different sections of the hearing officer's report, including support for standards for more PFAS compounds, comments on the EPA's national primary drinking water regulations for PFAS, comments concerning the implementation of the standards, and comments concerning the derivation of the standards and other health-based information. Again, the hearing officer's report has more details on these comments as well as the responses provided. So our 3 hearing officers were Commissioner Duggan, Commissioner Ellison, and Commissioner McDonnell-Gibson. Thank you to them for their efforts for this item. The recommendation of the 3 hearing officers is stated on the slide, and this is as stated in the report of proceedings as well. So it is the recommendation of the hearing officers that the proposed revisions to 15A NCAC 02L 0202, as noticed in the North Carolina Register, version listed on the slide here, on November 1st, 2024, to establish groundwater standards for PFOA, PFOS, and GenX be adopted by the Environmental Management Commission. So here is the anticipated rulemaking schedule. So as I said, at the September meeting, the EMC decided to approve the rule and the RIA for public comment. That public comment period was from November through December of last year. And through January and June, we reviewed the public comments and drafted the report. So now we are requesting approval of that hearing officer's report and final RIA, as well as adoption of the rule amendments. If approved, we would then go to the Rules Review Commission at their October meeting and ask for their approval. And if approval is received by the RRC, the proposed effective date of this rule would be November 1st, 2025. So the division is requesting that the EMC approve the hearing officer's report, approve the final regulatory impact analysis, and adopt the proposed rule amendments for 15A NCAC 02L 0202 groundwater quality standards as presented in the report.
Well, you're looking for a chairman and so am I, right? Well, without a chairman, let's take it on ourselves. Commissioner Edson, I think you were a hearing officer there, and I know you in the comments that's been provided was supportive of it. Would you give us some of your feedback from the meetings that you participated in?
Well, I would ask that you reiterate, as you did in the amended hearing officer's report, for the benefit of our new members, when do these standards apply? How will this impact the regulated community? Who is the regulated community in this particular instance?
Yeah, sure. So groundwater quality standards in North Carolina, those are the maximum levels of contaminants that are allowed in the groundwaters of the state. They are usually as a result of discharge. They're often used as cleanup values. So entities would be regulated in terms of cleanup for the groundwater.
Thank you. And I would commend staff for the voluminous comments that they had to sift through. 3 different meetings, lots of recordings, but that was a lot to pull together. Other than that, I think it's all pretty straightforward.
Okay. Commissioner Gibson?
I don't have any comments other than that, again, the staff has done a good job of handling a very controversial issue to get us to this point. And there was a lot of, at the hearing I attended, a lot of support for these standards, at the same time concern that the commission wasn't moving forward with standards for additional PFAS. It's a very emotional issue. I went to the hearing in Wilmington, and people there, their families have been directly affected by PFAS exposure, to the point that some people were afraid to have their kids drink water at school, and it has caused a lot of emotional stress. So I think a lot of people are going to be glad that we're moving forward with this. They're going to wish we were doing a lot more.
Thank you. And we have a chairman.
Had a little procedural stuff to take care of there for a second. So, Commissioner Baumgartner. So have you been both the?
I did hearing officers and now general comments.
And we're clear that the third hearing officer, Commissioner Duggan, is no longer on the commission. So we try to avoid that, but it happens sometimes. So Commissioner Baumgartner.
So Bridget, I guess feeding off of McDonald Gibson, Commissioner Gibson's comment, the other compounds that were not presented in this particular rulemaking effort, they were actually above PQL, recommended to go above PQL. Is that what I remember?
Yeah, so the 5 other PFAS compounds that the state had initially proposed for rule, those were health-based values, and those values were above the practical quantitation limit, which is the laboratory reporting limit.
But right now, you are regulating all these compounds at PQL.
Currently, we have IMAX in place for all 8 PFAS compounds.
Beyond the IMAC, you still regulate at PQL.
Yes, if the IMAX or standards were not in place, the PQL would be the regulation.
So it's not that we're not regulating PFAS. PFAS is, it's not that PFAS is not being regulated, that it is a matter of what the quantitative limit is for remediation, or what the target level is. Right now, the target level is PQL for all these compounds.
For anything not on 2L list without an IMAC, it's PQL.
Right.
So it's
Yes.
restrictive. It's very restrictive. And
What I'm
that's
saying is, it's not that we're not regulating PFAS. PFAS is
Correct.
being regulated in groundwater.
correct. And on the record,
Yes.
for the record, we had Director Scott that said in the debate and in the report that we didn't need to do this as a rule. This was more for public notification and awareness, not that we needed this to regulate PFAS, because we already have rules on the books that let us do PFAS at the PQL
Yes. Yeah.
and groundwater.
Mr. Chairman.
Yes, Commissioner Reardon.
Yeah, I know
Vice Chair
we're saying the same thing, but let's just be clear because I think in the last meeting, we wasn't very clear. The standards that were brought before this commission to vote on raised the standard to allow more of this compound in the water. What this commission voted was not to raise those standards, but to codify these standards for these three, PFOS and PFOA and Gen X. So it should be really clear that the vote of this commission was not to raise the level in which DEQ would regulate these compounds. We voted to allow them to regulate at the lower level, which is the PQL level, which was completely different than some of the narrative that was generated by the vote of this commission. Just so we're clear, all saying the same thing. Just want to put that out there. That's it.
Now, yes, Commissioner Zavaleta.
So just another clarification, and Tim, I was a little bit confused by what you said. So when you say PFAS, are you referring just to these three, or would it consider the others that EPA's already has addressed or is thinking
Yeah, let me
about?
take that. As I think most commissioner, a lot of you know with the PFAS debate, I think we're up, we said 7,000. I think the records say 10,000. There's a lot of PFAS
Oh,
compounds.
there's a bunch, yeah.
When we test by certain standards, we can test up to 40.
Okay.
For the MCLs for drinking water, let's make this clear. This commission does nothing to do with drinking water.
Right.
The MCLs for drinking water are done by the division, the Commission on Public Health. And so we're only about groundwater, about PFAS in the source water, basically, groundwater and surface water, source water.
But it's just how many PFAS? Is
Right.
it just the
It-
three, or are there others that would be covered in his comment about PFAS?
Everything on PFAS is covered at PQL if it's found. Yes.
The committee
10,000 of them could be regulated at PQL right
Great,
now
thank you.
The committee was presented with 8 compounds to consider.
by staff.
And 3 of the compounds lowered the standard below PQL, if I'm correct. Gen X
Two
was
did.
lower as well.
Two did. Gen X is still above, but we went with staff
Okay,
recommendation
okay, you're
because
right,
we
right.
didn't
Two
know at
below.
the time.
The
if Camilla-
remaining 5 compounds would actually raise above the standard of PQL. So we considered 8 in committee.
I had another question real quick. Commissioner Gibson beat you to it, Commissioner Smith. Commissioner Gibson.
Yeah, I think the point is very well taken, Commissioner Bearden. That, again, if the existing procedures stay in place, that compounds that aren't included will be regulated at the PQL. So thank you for reminding us of that. I did want to know, just maybe from Commissioner Smith or others, are there extra legal implications or risks associated with having an IMAC instead of a final standard? And if that's driving some of the community concern.
You better give that to me, maybe. You can take it, but
Okay.
Okay, so a few years ago, let's say this, General Assembly passed a statute that said IMAX, two issues. That's how I first got to know Ms. Shelton, is we had like 40 IMAX, maybe 52 on the books that had been there for maybe a decade, some of them. We had never cleaned them up. Those are interim standards. Okay, so just to explain that, those were interim standards. The directors approved those. And they do it with formulas and all that stuff to approve them. The way the APA works is if it's going to be a permanent rule, it needs to go through the public involvement process. And so what the General Assembly said a few years ago was all the IMACs at a certain point, which is 12 months, they will expire unless this body takes up rulemaking, because the IMACs have never gone through the public involvement process. Okay, so that's kind of the breaking off of the IMAC. It's kind of meant to be a interim temporary thing. If a site finds this contamination out there and has to clean up to it, and they want a higher level, like give me a break, don't make me do the PQL, they can petition the department to start an interim standard. But the way the law works now is after 12 months, if we don't take action to start the rulemaking process, the IMAC goes away.
And they have to clean up to the PQL.
They have to clean up to the PQL.
Okay.
Lower level, which is a lower level.
Okay.
Commissioner Smith, you want to have a comment?
Just along the same lines, I think there has been a lot of confusion, as Commissioner Reardon said, about what would happen with respect to adoption or failure to adopt these standards. I will say I regret the fact that we did not move forward with health-based standards for all 8, because that would not have imposed more strict standards on the regulated community. Instead, it would have actually helped some landowners and some responsible parties who need to clean up groundwater by providing them with a health-based standard that is above the PQL. And it's a little bit ironic that we're now in the situation where for those we chose as a body not to move forward with in rulemaking, we're now relying on interim maximum allowable concentrations, which, as you say, are temporary. And many members of this commission have not been comfortable with using IMAX for extended periods of time. So we had an opportunity to move these forward as a group. I wish we had done that. I'm going to vote for these. I think this is a good rule, but to me, I can't follow the reasoning of dropping the other 5 when in fact those would have made the rules less stringent, but still would have maintained a health-based standard for those other 5.
Okay. Let me go back. The majority went with those 5 and to keep it at PQL. There's a lot of uncertainty around PFAS. There's a lot of uncertainty around thousands of compounds, right? So instead of locking to some level that may change with a health-based equation that is subject to change as well, we default it to PQL. Keep as much PFAS out of the water as possible. So while PFAS is being debated at the national level and whatever level, we decided as a body to keep it as stringent as possible, even for cleanups. So we didn't give anybody a break on the cleanups, even though there was an equation that changes from time to time. We didn't want to get locked into anything other than PQL, and that was the decision. Now, after that decision would be made, and this is just for disclosure, after we made that decision, the department went back because they have the power without consulting us and adopted all 8 as IMAX. Putting more PFAS in the water than allowed. And they say, well, that's a health-based standard, but either way you look at it, PQL is less than a higher level that the IMAX do. As a body, we decided not to do the 8, to do the 3 for rulemaking, and that's what you see before you. Those other 5 IMAX adopted to department will expire on October 15th. Now, we did not have a report or an action item in front of us today, and they've asked maybe we should do a report on a recommendation, but we don't have any recommendations here, and this body has already decided to do the 3 with what's before us. So we won't take any action on the IMAX at this point, and they'll expire, and we will regulate. Practically speaking, we will not have a higher level for those 5 or those other 10,000 will be at PQL. So we will keep as much PFAS out of the groundwater as the laboratory methods let us. And then once we get some final determination from some other body about what it needs to be, we will raise those levels up or screw them down a little tighter. But right now, this body had previously decided do these 3 in public interest, and then the other 5 will wait till we get more definition, but regulate it as tightly as possible for now. So that's it, Commissioner Tweedy.
I don't want to belabor, but I'm still trying to get the answer to the question that I think was asked. Does having these 3 in standard versus, or in rule versus managing the others to PQL, do they all have equal regulatory strength under the law then? Or are the one, do you understand what I'm asking?
Well, I think you heard, let me try to answer that. I think these are used in a multitude of programs. When you look at IMAX, right, they're using hazardous waste programs, they're using our landfill programs, they're using all kind of programs, right? You heard yesterday, somebody talked about that, one of the things about how SRF money was given out. They look for these standards, and if they see these on the list, they'll look for that standard. So these are being used in one form or another by several different environmental programs. These 3 will be on the hot list for everybody to look at. The other 5, the other 1,000, the other 40, whatever it is, won't necessarily be, but if they're found out there and they're reported to DEQ, they will make them do the PQL, which will be take all the stuff out. So legally, it doesn't change anything. They still have the same rules in effect to regulate at PQL when they find them in the environment. On the practical side, if you remember the report, and DEQ was very explicit in this report, but this hearing officer's report, it was a fiscal note, said that if we get PFOA and PFOS and remediate those with the current technology, it will get most or nearly all of the other ones, more short chain one. So from a practical standpoint, if these are on the books at this, lower than PQL, and we remediate for the long chain, what we've gotten from DEQ in the report was that will take care of much of the other short chain ones that are the other thousands that are out there. So I feel protective because if we start remediation to the long chain or these first two performing PFAS, we'll collect for their report most of the others. Mr. Gibson.
Yeah, I'm belaboring this, but just as a point of potential interest, these 2L standards are actually really important when communicating with private well owners, and very significant fraction of the population in the state relies on private wells. It kind of depends, it's uncertain, but as much as a third. It's actually, one recent estimate said we're the highest in the whole US among states for reliance on private wells. And these folks aren't subject to the Safe Drinking Water Act, and so they have to manage their water quality on their own. And I've done recent work testing private wells for PFAS, and it's very confusing to tell people what it means when we find PFAS. It's much more of a comfort to them if there's some kind of a limit like a 2L standard, and we can say, okay, you're below that, you don't have to worry. But if the standard is just the practical quantitation limit, it means anytime we detect anything, then the practice is in the Division of Public Health, which provides basically support for private well owners, to tell them, well, your water isn't safe to drink. So there is some other benefit to just having a little bit more certainty on standards. It causes people a lot of distress when you tell them your water isn't safe to drink because we've detected some PFAS, even if they're at really low levels.
Yeah, and again, this is one of those crossover areas, to agree with you, Commissioner Gibson, 100%. And it is confusing to the public at times. We had that issue that media picked on a year ago about the school over in Farmville or wherever that had a well, and they had PFAS in the water. And people came to start screaming at Joe and Tim because they were not regulating it in groundwater. Well, the truth is that was being used as a water supply source, a public water supply source, and should be being regulated by the Commission on Public Health, not this body. There was a responsibility to clean it up by that body, but the standard was not set by us. It was set by the Division of Public Health, and they had not had a standard for that. So they may be using PQL too, but for this body, we want to use PQL.
Well, it's the health department just advises private well owners. There's no standards for them. And their practice right now is to say, if there's a contaminant present in your water and there's a 2L standard for it, that gives us some kind of reference value. Yeah,
Right.
so it's
Maybe
helpful to have reference values.
Yeah,
That's
but,
what I'm saying.
yeah, I agree. Maybe not every, yeah. Any other comments, questions? Yes,
Just-
Commissioner Chmielewski.
I guess maybe for Commissioner Gibson, but I don't want to give people false reassurance if the standard is higher than the PQL, because we know these compounds are bioaccumulative, they're not naturally occurring. So I don't want to give false reassurance that it's a low level, but it's below the standard. See what I mean? I don't know. Do you have suggestions for that concern?
That's a good point as well. I do think we really can't answer the question right now of how much is too much for safety. It is helpful when communicating to at least have some reference point to tell people, whether that's, that's gone through some kind of an evaluation process.
Yeah, I guess I can see that if I compare it to lead, like we
Right.
have no lead is good. But we have a standard to
Right.
say we need to chelate or we need to take action on this lead, and okay. Thank you.
Yeah. Questions? Yes, Commissioner Hardison.
Have we, pardon, this is possibly an ignorant question, but I'm catching up. Have we made any facilities or anyone clean up to this level?
The proposed values,
Well, either one, the IMAC or the proposed value.
it is my understanding that, yes, the IMAX have been in place since October of last year. So I do believe that they are currently being implemented.
Okay. So then for the regulatory impact analysis, the fiscal assessment, was it based on what people are doing now to clean up to this level, or that or is it as the baseline that nothing's being done right now? So the fiscal note is assessed above that?
The baseline in the fiscal note was the PQL. OSBM, the Office of State Budget and Management, do not view IMAX as a baseline.
Because they're not adopted by statute or rule. They're just an interim standard. Is the reason they don't consider it the baseline.
Okay.
It's temporary.
I'm
Yeah,
s-
to answer your question though, I don't know how many they're doing with these other 5 on the IMAX. But what would be required is they only would delineate the plume out to where they found it go to that level. When we suspend this or the IMAC expires and those people that have done assessments would have to expand it to find the PQL. So they'd have to find the end of the boundary, not just stop at where that level is in the PFAS. Now those are down to decimal points, but it would make people that are using the interim standard maybe go out further and find out the full extent of the PFAS, which I think is a good thing personally, but that's up for y'all to decide. That's
So the
another
cost
reason.
assessment takes that into consideration?
Not for the
fis-
regulatory impact analysis.
And it doesn't need to?
No, because it'll be the PQL.
Okay.
The debate often becomes, it doesn't violate the baseline, so it adds no cost. And then what we hear a lot from the regulated community is, but you're putting 3 more things on the books. That adds cost to us because we've got to monitor it and track it. And so there is a cost to it, but the way you're doing your regulatory impact analysis as the baseline is PQL, you could add 1,000 on here and say there's no cost to them. And what industry will say, or the regulated community says is, well, you are adding cost to us, but you add all those in. So that's some of the argument that's made for regulatory impact analysis. So I don't know if that answers your question, but that's around the topic. But for now, we're where we are with the PQL. Commissioner Scott, you got a clarification on that?
I want to add to your comment, Chairman Solomon, just one example that may help. Probably one of the most extensive data sets right now is the sanitary landfill data set for groundwater. Over 200 North Carolina facilities sampled for PFAS in their groundwater. And a couple of reference points, I think that what the commission is discussing right now for PFBA, none of the landfills exceeded the IMAX, 7,000 part per trillion. But there are detections above the PQL. So PFBA is an example, and PFBS and PFHXA. So over 95% of the landfills have a detection of those compounds above PQL, but they're below the 2,000 and 4,000 respectively. So to the chairman's point, depending on the final decision of the commission with the 3 compounds, those landfills will be screened point forward at the PQL. And the other part, landfills are in continued assessment right now, collecting more data. We do have some remedial systems going in, meaning actually, clean up the contamination, remove it. But hopefully those examples on those other compounds help with the PQL to the IMAC discussion.
It does. Okay. Any other comments, questions? Okay. Thank you, Ms. Shelton. Commissioner, now I'm looking at Baumgartner. Commissioner Ellison, you were the lead of this hearing officer here for this report, right?
I guess
So. Was it Baumgartner? Which one was it? Who led it? Yeah, Ellison. You're looking at me with a blank look.
And,
Gibson.
McDonald and Duggan.
And Duggan.
So I will make a motion that the EMC approve the hearing officer's report, the final regulatory impact analysis, and adopt the proposed rule amendments for 15 ANCAC 02L.0202 groundwater quality standards as presented in the report.
Okay. Do we have a second?
A second.
Commissioner Keen seconds. Discussion on the motion. Any discussion among the commission? Okay. Call for the vote. Let's raise our hands so we don't run the last time. All in favor, say aye and hand to show. Aye. Okay. Any opposed? Okay, it's unanimous. Thank you. Motion passes.
That's
Very good. Well, it's good discussion, and I think it proves that if we find the points of agreement and we have good discussions among the members, we can come to good conclusions. And I think this is a first step. The journey is not over with respect to PFAS and either in groundwater or surface water, but this is a good step along the way. So thank you for all your participation here. All right, next item is 25-36, request to approve the hearing officer's report of proceedings. And and adopt the 2023-25 triennial review. And Chris Ventilaro will give us that one.
All right, well, thank you, Chair Solomon. Commissioner Ellison, I think, just stepped out, but I was going to thank him for being our hearing officer for this rulemaking. Good morning, everyone. Again, my name is Chris Ventilaro. I'm the Water Quality Standards Coordinator with the Division of Water Resources. And as Chair Solomon mentioned, we will be seeking approval to proceed for adoption of the amendments to the 2023 through 2025 Surface Water Quality Standards Triennial Review and Regulatory Impact Analysis. I'm going to apologize in advance because I think I also forgot to put that on there, which I normally don't. So I apologize, but I'll remind whoever ends up making a motion at the end. So I'm going to start off with just a quick overview of the triennial review introduction and rulemaking timeline that's occurred so far. We'll talk a little bit about the public comments on the proposed triennial review revisions and the regulatory impact analysis. We'll talk a little bit about the public comments on some other triennial review topics. We'll discuss the proposed timeline for the Rules Review Commission and for EPA approval, should this commission approve of the amendments today. And we'll, of course, provide an action item request to adopt the proposed triennial review amendments. So I know we have a few new commissioners here today. The triennial review, for anyone who may not be aware of, is a rulemaking process to adopt surface water quality standards in Carolina rule. For surface water standards in particular, the Federal Clean Water Act requires that states adopt surface water standards to protect surface waters. And they list the EPA as the administrator of the Clean Water Act. And there's a few things that we have to keep in mind when we're going through the process of surface water standard adoption. These requirements here are listed in EPA's rules or regulations at Title 40 of the Code of Federal Regulations, Part 131.20. Some of the things we have to keep in mind are that states must hold a public hearing at least every 3 years to provide the opportunity for the public to comment on surface water quality standards. As part of the surface water standards review, the states review their water quality standards, make recommendations for updates if necessary, and they also review any criteria, 304A criteria that EPA has published in interim. States must provide scientific justifications for changes to water quality standards and document reasons for states not adopting 304A criteria that they don't currently have in their rules. And then ultimately, states must submit their water quality standards review to the EPA for Clean Water Act review within 30 days of final state action. For this triennial review, we actually started back in, I believe it was January of 2023. I didn't put the full timeline of what's happened on here, just in the interest of saving space. But some key points that got us to where we are today is that the North Carolina Office of State Budget and Management approved the fiscal note for this rulemaking process, or the RIA, on October 29th, 2024. The Water Quality Committee approved the rule package to proceed to the full commission for consideration on November 13th of 2024. The EMC approved the selected items in this rulemaking package to go out to public notice and hearing on January 9th, 2025. We filed for the NC Register publication on February 10th, 2025, and then the notice of text in the NC Register was published on March 3rd, 2025, which also began the public comment period. A public hearing was held on April 22nd, 2025, and Commissioner Ellison was kind enough to be our hearing officer for that public hearing. And then the public comment period ended on May 2nd. And then that brings us back here today to seek adoption of these proposed amendments. Now, the full commission approved 2 proposed amendments to proceed to public notice and hearing. The first proposed amendment was to update the recreational standard for primary recreation waters in 15A NCAC 02B 0219 Part 3B to use E. coli as the bacterial pathogen indicator. A little bit of history for the new members. North Carolina classifies recreation waters in 2 ways. For Class C waters, which are provide the basic level of protection for all fresh waters in the state. Class C protects for secondary recreation, which is recreation that occurs that is more kind of partial body immersion. So things like wading, fishing, canoeing, kayaking, etc. And areas where regular, frequent, full body bathing doesn't occur on a regular basis. Now for Class B waters, we classify primary recreation. And this is those water bodies that the commission has determined that are suitable for full bathing in surface water. So these are waters where people are swimming. Their likelihood of them ingesting water is greater. So there's a greater likelihood that they could potentially be exposed to organisms that could result in gastrointestinal illnesses. And this is what this standard is basically looking at. Now, North Carolina currently has a standard for primary recreation in O2B, O219. And that standard has been in place since the 1970s roughly, and it uses the fecal coliform bacterial group as the pathogen indicator. So this proposal to update to using E. coli is basically kind of updating to what EPA has been currently recommending. They published criteria in 2012 to recommend a switch from fecal coliform to E. coli as a bacterial indicator.
Hey, Chris, just to clarify, like for Commissioner Jasper, who has a background in this,
Yes.
one of the reasons we had a lot of data historically. So North Carolina ended up being one of the last states to move to this standard. So out of 50 states, I think we were one of the last 6, Chris, or something to convert.
Yeah, that's true. And all of our surrounding kind of region 4, what we call EPA region 4, all of our surrounding states have been using E. coli for some time. So this is kind of getting us kind of on par with them and on par with what EPA has been recommending, at least since the 90s, really. So the proposed language you can see here in the box, and I'll read through it very quickly. O2B, O219, Part 3B, Escherichia coli, full name of E. coli, shall not exceed a geometric mean of 126 per 100 milliliters. Its colony forming units are most probable number based on at least 5 samples taken over a 30-day period. Escherichia coli also shall not exceed 274 out of 100 milliliters. Colony forming units are most probable number in more than 20% of the samples examined during such period. And this form of this rule is exactly the same as it is now with the fecal coliform, just switching out the E. coli indicator and the specific numeric criteria and adding the option to use additional test methods by way of including the most probable number as a unit of measurement. Whereas for fecal coliform, it relied strictly on colony forming units. And this opens up some possibilities for analytical measurement that provides some cost savings and some newer kind of test methods. So we received 168 comments from non-governmental organizations, citizens, businesses, as well as EPA. All of the comments supported replacing fecal coliform with E. coli. They indicated that benefits include cost savings to stakeholders, consistency with other states, E. coli being a better indicator of gastrointestinal illness, as well as by making the switch, it will use the most recent science to protect recreators. Kind of coupled with this is that we had 167 comments that also requested that E. coli, these update to E. coli, also be expanded to include all Class C waters as well. So right now, with the passing, if this rule were to be passed, our Class B waters would be updated. Our Class C waters would still use fecal coliforms. And there were a few reasons for that, the way we kind of did it with this. So partly this focus came from concerns expressed for Class B waters in the western part of the state. And we conducted a study to compare fecal coliform and E. coli levels to help us determine what the most appropriate criteria would be. And we were only able, given the time that we had and the resources, we were really only able to look at Class B waters. So.
And I think it doesn't have to end here if we don't want it to, but from a procedural standpoint for the new members, this would be a major change if you said, let's make all the Class C water. So after the debate and through the rulemaking, staff came down to this, the EMC, previous EMCs agreed, so we went to rulemaking this way. You could add Class C waters at this point, but we'd have to go back to the regulatory impact analysis, redo that, go back to public hearing, because this would probably be a substantial change based on Class C waters. So I think from a procedure standpoint, we're much better to make this progress. And then if this body decides we want to move that to Class C, or the department, when they have the resources, we'll move it to Class C. But I would probably say this is a pretty good first start to get us to the equalized standard as a state, and something we've talked about for a while. So it'd be good to get it moving. So I had that for you, Chris, instead of you having to say that. So
Yep, thank you. So that brings us to our second proposed amendment for this triennial review. And this amendment was to basically just clarify the requirements for water quality standard variances that appear in 15A NCAC 02B 0226, just by including a reference to Title 40 of the Code of Federal Regulations, Section 131.14. And this was something that EPA requested that states do. So North Carolina currently has an option for the regulated community to seek a variance from a water quality standard. And these variances are basically temporary adjustments to the water quality standard that they will meet so that they can make incremental improvements over a longer period of time. And so this language already exists. This process is already available. What EPA wanted states to do was to just more clearly indicate where the federal requirements are located to be able to obtain a water quality standards variance. So this rule amendment does that by just inserting just a clause to basically reference that Title 40 CFR rule. For public, yes.
I've got a question, Commissioner Reardon.
Just one question here. Would shellfish sanitation does reference certain water quality standards when closing waters to harvest and shellfish. Has this been vetted with shellfish sanitation? Do they reference in their rules these recreational standards as it would relate to commercial harvesting of shellfish in those waters, or are they using an independent standard? So has this been communicated with them, and does this have any effect from their perspective on harvesting shellfish or any impact to those programs?
No, so the change to the E. coli in the primary recreation waters. So I should have been more clear. This change for primary recreation focuses strictly on Class B waters, which are just the freshwater primary recreation waters in the state. The Class SB rule focuses on primary recreation waters in the coastal waters and the salt waters. So for recreation, there's a separate category for that, but they also have to meet their own shellfish sanitation or shellfish water quality standards for the safe collection and consumption of shellfish, which are also harmful. So there's kind of two different things.
Yeah, just want to make sure there wasn't any unintended consequences here that they were not aware of.
And just curious, what indicator do they use?
So for shellfish sanitation for consumption, I believe they're using fecal coliform, if I'm not mistaken. For recreation in Class SB waters, that is Enterococcus. Or Enterococcus, however people like to say it.
All different.
Okay, good. All right, continue on, Chris.
So for the variances for the public comments, we have received 2 comments, one comment from an NGO and one from EPA. Both comments supported, including a reference to the requirements for variances in 40 CFR 31.1. That brings us to the regulatory impact analysis. So the regulatory impact analysis for this rule package basically determined that there would be, for the E. coli proposed amendments, that there would be cost savings of approximately $0 to $25 per sample for facilities covered under NPDES wastewater and stormwater permits. States that no costs are anticipated to the state's lab certification program or to commercial laboratories, because many of the laboratories already do this, the E. coli methods that are most popular. And that there's also expected to be a net cost savings of about $1,150 annually to the state's ambient monitoring program. And again, that comes down to, the popular test method for monitoring E. coli in surface waters is the co-alert method. And after initial setup, over time, it's actually less expensive, as we understand from our laboratories, to actually run this analysis than it is to do the traditional membrane filtration methods. For the update to the proposed amendment to update the language for variances, There's no economic impact, as I've mentioned. This imposes no new changes. Any requirement that's stated in Title 40 of the Code of Federal Regulations, people would have to meet that regardless. So this is just trying to provide some clarity so people know where to look to specifically see those requirements. We did receive a few comments on our RIA, so 2 comments were received. And the comments basically were focused on that they mentioned that the true cost savings of the RIA are actually underestimated. And they stated this because they feel that the RIA generalizes the cost savings to the regular community and that it didn't count for the total number of samples that would be analyzed by facilities. And permitted facilities are often required to perform quality testing. So the comments basically felt that if you looked at the individual number of tests that each facility would do, you would realize a much bigger savings. And that wasn't done as part of the RIA originally, just due to staff availability and timing. So we also received public comments on other topics. Now for the new commissioners, when we go out to public notice for training or reviews, we're supposed to not only go out to public notice with the proposed changes, but basically it opens up for people to comment on anything related to surface water standards, including variances and water body classifications. So we did receive comments on a number of topics, as you see here. We received 16 comments on 1,4-dioxane. All of the comments were in support of adopting standards for 1,4-dioxane. As I mentioned, we received about 167 comments requesting that E. coli be expanded to include Class C waters. One comment was included mentioning a clarity standard, and NCDEQ is actually in the process of developing a water clarity standard. And this water clarity standard is really focused on the protection of submerged aquatic vegetation out of the coast. So that's being developed in what we call the North Carolina, the Nutrient Criteria Development Plan process. So that's about halfway through the process.
And for new members, there was a presentation last meeting on the clarity standard, if you want to go back to that meeting.
We received, sorry.
No.
Okay. We received 5 comments related to requesting cyanotoxin and or harmful algal bloom criteria being established. And we do not have currently numeric criteria for cyanotoxins, but we do have a very involved harmful algal bloom kind of monitoring program where Division of Water Resources works very closely with the local health departments and with NGOs. We have an app online where people can report harmful algal blooms that they see when they're out on the water. We have phycologists at DWR that will determine the specific species and cell counts and can do some testing of microcystin levels. So we have this program in place, and these comments were really requesting possibly adopting numeric standards. One comment was related to flow. 2 comments were related to human health criteria updates. One of these comments was requesting that North Carolina update all of its surface water human health criteria. Another comment was from the American Pulp and Paper, as well as the National Council of Air and Stream Improvement. And those folks are requesting that when updating human health criteria, they're requesting that the commission consider the use of probabilistic risk assessment methods in the development of those criteria. Right now, we use kind of the traditional kind of deterministic method. It's a single calculation with set exposure factors. This probabilistic risk assessment method would kind of change that up a little bit and use more kind of data ranges to end up calculating the criteria. We received 4 comments related to plastics, both micro and macro plastics. One comment received related to temperature concerns in trout waters. One comment related to thermal dischargers, and 3 comments related to the existing rule language for turbidity. So today's request, and again, I apologize in advance because I did not include the regulatory impact analysis, but the request for today would be for the commission for approval of the hearing officer's report of proceedings and the regulatory impact analysis for adoption of the 2023 through 2025 surface water quality standards triennial review amendments to 15A NCAC 02B 0219 and 0226. And just lastly, if the rules are approved today, we would be going to the Rules Review Commission for approval in October likely, with Attorney General sign off during the winter after that, and then final submission to EPA for Clean Water Act approval, either at the end of the winter or early spring. That is all I have for you today. I'm happy to answer any questions.
Commissioner Ellison is hearing officer first. Any comments or clarifications from your perspective?
A couple comments. Chris just mentioned and if you would say the proper name, the pulp and paper and the stream guys.
Yes, pulp and paper, American Pulp and Paper Industry, as well as the I believe it's the National Council of Air and Stream Improvement.
Yes.
Yeah.
Their comments and subsequent bird dogging on that source of all truth and light, the internet. It's very interesting to read. And I would recommend anybody with a little spare time that it's worth the effort. There were a lot of comments about PFAS. I didn't know it was only 19. I thought it seemed like a lot more. An attorney from SCLC said you, and I don't know if that was me personally or you in the plural sense of the commission, are responsible for a lot of deaths related to PFAS, and an unsubstantiated claim, but it just was not in the triennial review, and the commission has decided or had decided that it would not be in the triennial review, so that train could go down the tracks. I just bring that up because it was very unsettling. I felt like it was largely inappropriate. Not that all the other people who commented about PFAS, not that that was inappropriate, but the accusation of being the source of mortality. I would also note that it was a lot of the comments were very well organized and choreographed and performed by a lot of river keepers and very earnest, well-meaning people, some of whom had some very good comments. Would guess the majority were in favor of what we were doing, particularly with E. coli. But it was an interesting public hearing.
Okay.
So I'll wait on a motion until
Yes.
you go around.
Questions from commission to either staff or hearing officer Ellison? Mr. Smith.
So one question about the next steps for Class C waters, because it does seem like we're leaving that sort of hanging out there in a way that in the long term, it would make sense to have a consistent standard. And so I know, I agree, it would be probably a mistake to add it at this point because we would have to go back to public hearing. But either today or at a future presentation, I'd be interested in knowing what the department's plan is for assessing those Class C waters and the potential for expanding this standard to those waters as well.
Yeah, and back to Chris, to agree with you 100%, but to Chris's list, go back to your list, Chris. One of the most beneficial things we get out of the training review is we kind of get some comments on things that we weren't put in this package. So we could take as Commissioner Smith said, we could take it up as separate rulemaking. After this, we could begin it right away, or we could wait till the next training review to include the Class C waters in that. There's a lot of options here. But I do think, just my thing here is the cyanotoxins. I don't think we're doing a good, I've said that for years as a state because I've worked closely with a lot of these moccasin lakes down east. There are a lot of algal bloom problems and a lot of HABs that are out there that we as a state need to do better. Is we don't have the resources to get to the smaller bodies, but those are very, very impactful in their communities, into the wildlife, into the swimmers. And we just need to figure out a better way to regulate those or to address those. And I know we're doing doing the best job we can, but that would be one of my passions as well. But that's probably a couple of years away from making that happen, maybe in the next triennial review. Other comments or questions about this triennial review? Yes, Commissioner
One
Smith.
thing I forgot to say, I want to be sure, well, I can't be sure, but I hope that former Commissioner Deerhake is listening in on this meeting. As much work as she did on the transition from the fecal coliform to the E. coli standard. It was something she was very interested in and pursued over several years.
Maybe we'll get a text from her and see if she, after 20 years, are you still listening in, Mr. Deerhake? Are you having withdrawals or not? So, okay.
One thing I will say real quick, just for the benefit of the new commissioners, is that, this triennial review cycle is ongoing. As one ends, another one begins. So assuming we have approval today to kind of accept these proposed amendments, we're already looking at stuff for the next triennial review. And we typically start off by providing a presentation to the commission, kind of going over the process a little bit more in detail about what standards are, et cetera, and then listing out a whole bunch of topics that just to make the commission aware. So that's something that will certainly be coming in, the future.
Okay. Hearing no other comments or questions of staff or the hearing officer, I will go to hearing officer Ellison for a recommendation or a motion. A motion.
I move to approve the hearing officer's report of proceedings and adopt the 2023-2025 Surface Water Quality Standards Triennial Review Amendments to 15 ANC AC 02B 0219 022 or 0219 and 0226 and the associated RIA.
Okay. Motion. We have a second. Second from Commissioner Yarborough. Any discussion among commission on the motion? Hearing none, all in favor, please say aye.
Aye.
Any opposed? It's unanimous. Motion passes. Thank you, Chris. That's all of our action items. As I've sat here today and thought a little bit about all the things on our plates. Couple reminders before I go to director's comments and comments from the commission. We had some discussion yesterday on source monitoring and minimization for PFAS. We expect that in committee next time. That was one of a two-pronged approach for new members. We had proposed rulemaking about a year ago to do a quantitative standard. It became clear in committee we weren't going to, the information was not ready for a quantitative standard yet. We had a two-pronged attack on PFAS to move forward. One was with identifying the contaminators, if you will, on a very aggressive, holistic basis across the state. So that's really what the testing and minimization rules you'll start to see in committee next time will be. There was a parallel track to get to the regulatory impact talked about PFAS in food. And so that was long and short, the quantitative standard really didn't get out of the benefits analysis because it was hard to quantify the benefits and justify the benefits, at least on paper. And so one of the things we decided to do was start talking to FDA and USDA about what is the status of the food in North Carolina. Vice Chair Reardon and I, and that's one of his expertise, have had a conversation with some officials in Washington, D.C. with FDA to get that process moving. The simplification of it is probably that FDA is going to address it, I think, in this next couple of year cycle, but it is not top of their list. Some of the tops of their list are those classes of people like babies and the elderly. So the current initiative right now is looking at baby food, where they're testing for PFAS in baby food, but the main driver there is metals. Supposedly there's a lot of metals in baby food, or potentially because it comes from other parts of the country or not being regulated. So our understanding was something will happen with PFAS, but right now, the big initiative with them right now, the orders they say are toward the baby food. So we're monitoring that. We're going to have deeper discussions about some of these things as we promised a year ago and out of committee. But that's the other parallel track to get to a numeric standard is to move that to make sure we can get our RA right and get agreement on what the numeric standard needs to be. Just adding the MCLs, which is not our prerogative, but they're a baseline. As most of you know, there's lawsuits going on about those, and the current administration is trying to figure out what to do with those. So hopefully in the near future on the quantitative part, we will make good progress. But the short term, we can do something with source monitoring and minimization, which is a big step because it'll help us identify all the polluters and really keep things in the fence line, not in the water bodies or in the wastewater plants where it's incrementally more expensive to treat once it gets into the natural environment and into our communities. Keeping it inside the fence line is really how to control it best. So that's the status on that. The other status I give you, and I'm gonna let Richard Rogers, Director Rogers, if he wants to start. I see Forest West Hall, we got a little bit of time. I was trying to wrap up by 11, but I'll give you a couple minutes, both of you. But we heard about Falls Lake and the previous commission. I don't want to go into all the history of Falls Lake, but they've had a stakeholder process for a couple of years. The state's been active. The state's planning on bringing rules to us at some point. The Upper Neuse Basin Association is planning on bringing us rules, I believe, as well. And what I've encouraged both parties to do is to please get the issues together as much as they can. I'd rather not have, I think this commission, I'd rather not have dueling rules, but if we have dueling rules, my term, not a legal term, we need to identify the hot spots so we can make the decision. The rules are ultimately ours to make decisions. And so this body will have to decide how to break those ties. So Richard, I'll give it to you first and then I'll give it to Forrest. Anything you want to say, what's coming from you guys or when, and then I'll go to Forrest.
Okay. Thank you, Mr. Chairman, members of the commission. We continue to work with Forrest and his group. There are 2 or 3 hard points that we're working through. We meet regularly and we'll continue to do so, trying to make sure that we get everything resolved that we can and look forward to the ongoing conversations and look forward to getting before the commission as well with that rule. Thank you.
Thank you. So Forrest Westall, a few things about Forrest. Forrest is a former EMC member. I think you served for about 10 years on the EMC. I'm not sure.
About 5 or 6.
About 5 or 6 on the EMC. He's been a water quality expert. He's a consultant now in that world, and he's director of Upper Neuse Basin Association. Oh, you brought handouts. You gave out handouts last time too, but that's good. Upper Neuse Basin Association, I'll mess it up and he can clean it up, but it's about 30 members. Most of those are local governments. People like Raleigh, Cary, as small as Roxborough and those people. Huh?
Not Cary.
Not Cary, okay. Yeah, they're Cape Fear, anyway. Durham, right? Durham. So he represents a lot of the major industries, and his stakeholder groups has included people like DOT and the ag people. So as Richard said, I think everybody wants these Falls Lake by statute to be adopted or readopted, and we've got about 10 years of data. So we'll hear some rule modifications coming shortly. But Forrest, if you'll give me a quick update. I appreciate the handout.
I apologize. I know that there's been new members and I welcome those members and I thank you. And if you clarify the word that was said, congratulate, but I commensurate with you on being on the commission because there's a lot of material you have to deal with. I passed out a very brief summary, but mainly I think the new members I've presented to the commission probably 3 or 4 times over the last 6 months or so, summarizing where we've been. The UNRBA has spent, I've been with them 13 years, and that last 13 years, we've spent $11 million assessing the lake and the watershed and providing the best science we can to support the rules readoption process. We gave our report under the general statutes, which was required at the end of 2023. The collaboratory gave its report in the end of 2023 as well. And the UNRBA undertook a program to bring in stakeholders and people that were interested in that, both from the environmental community, from agriculture, from the development community, from the watershed, from DWR. And we met 22 times over the last between December and April, and we've been working on it since then. DWR released a draft of their rules on the 25th of August. And so we've been trying to digest those and go through those. We will make modifications to our drafts. Our goal right now is to take a set of draft rules that have been vetted through this process with all the input that we've received to our board in September, in October. We're going to have a special meeting in October to do that, and then bring those, if possible and if allowed by the commission, to the commission with a summary or a report that will kind of go through what they have in there. And also, we invite DWR to present, because we do have about 4 or 5 very critical issues where we are in a different position on. So that's very important to the folks in this watershed. The original cost of the rules were estimated in the analysis to be $1.5 billion. So it is a tremendous impact. There's only about 250,000 people in the watershed. 500,000 people use Falls Lake as a water supply. So it is an extremely important, if you look at the population of the state, you're approaching 1 million people that are impacted by Falls Lake. And so this is extremely important. This is a unique situation for the UNRBA. We are working to partner from the regulated community with the state. We know, and I know, because I worked for the state for 30 years, that the state has the main responsibility for writing rules. But we believe with our investment and effort that we've earned a place at the table to be able to work on those rules. And the general statutes does give other persons the opportunity to make rulemaking. We don't want to go that way, but we want to leave that option open. And the board of our membership, which does include Raleigh and Durham and Hillsborough and 5 counties in the area, are very interested, because this is going to be a tremendous impact on their citizens and the cost ongoing. This is going to be a lifetime. It's going to go on forever. Management of the lake never ends. You have to manage it forever. And so we want to be in partnership with the commission and with the division and with the department. Thank you.
Okay, and thank you for being brief. You're brief. I want to make sure on the draft rules, we understand nothing's been released to public on draft rules yet. Forest's group, I hate to put a name to it, but Forest's group, UNRB, had started drafting rules, and they've got rules mostly drafted. The state drafted their own rules, and as I understand it, sent them to Forest for his group to review. So there has not been any draft rules that has come to the EMC or to the public yet, just to clarify. But looking at those rules, they are in some conflicts, that there've been some conflicts. So I'm encouraging them and this group to get involved, because we are the rulemaking body. When this comes from either party or both, we may get a petition for private rulemaking. They've got consultants and lawyers working for them now too. And the department's got their people. I hope everything gets merged together before it comes to you. This will come to the Water Quality Committee first. And like all of our committees, it will be their job to hammer these issues out, hopefully to 80 or 90%. But we have to keep the whole commission involved in this process. And given the magnitude of this, we may have some presentations to full commission before we go out of committee. We haven't talked about that, but we could. So
Just real brief, 1 sentence, what's the differences at this point?
Characterizing some of them, I think one is like land conservation. It's been a debate for years about how much conservation can count toward kind of mitigation services. Is it 100%? Is it 0? The state's had a 0 approach to it. I think probably most people would say there ought to be some reward for that. Is it 100%? I don't know. And there are other clarifications. That's okay, Forrest. But he's got some of those in handouts. He gave out some stuff before that's probably in the minutes. And just look at it and you'll hear about it. I don't want to circumvent the committee process here, because it needs to go through committee and let the committee work. But I think with new members being here today and it looked like a short agenda, I thought if we had a few minutes of time, we could add it on just so the whole commission's aware of it and you can track, again, what we're doing. I delayed a presentation on High Rock Lake. High Rock Lake's had a similar history like Jordan Lake and Falls have had, but they're at a point where they're getting ready to do rules for High Rock. So this will kind of be the year of the nutrient and this nutrient management strategies. So you will see High Rock probably coming as an information item in November, where I put off all the presentations of High Rock until this commission fully was in place, this new commission. So those are the 2 things I had. Commissioner Smith, question?
Yes, just a question. And partly for the benefit of the new members. I mean, there's been a reference, I think, by Forrest and by the chair to private rulemaking, and there really is no such thing. I assume what you're talking about is a petition for rulemaking in
Yes.
which a party can come to the EMC with a petition asking the EMC to move forward with a specific draft rule. So we can do that. I will say, I hope that's not the path anyone's on. I think it would be a mistake in a situation where the EMC is already engaged on an issue and moving toward rulemaking, to have that process short-circuited by a petition for rulemaking from any party. So I'm not saying, maybe that's allowable under the statute that allows petition for rulemaking. I think that is not a practice we want to encourage. If we are undergoing a rulemaking process within the commission and its committee, that's where these conflicts can be and should be resolved. And I would hope we're not inviting a petition for rulemaking in that context.
No, I think, but it is the right of any citizen or individual to petition us for rulemaking, and some we have.
Yes, I don't disagree with that.
So it is possible, and I cannot think of one in my knowledge, and maybe you can't either, or anybody else that have been on the EMC a long time, where we've had these dueling rules come in. But I do think the statute may allow it, but I'm trying to make sure these guys, and I'm going to continue to work with them, are finding the rough spots so we know what they are. And so, to your point, I would rather have one set of rules. I think everybody would rather have one set of rules and know the hot spots. But let's see where it goes.
Yeah, absolutely agree. And I think the committee and then the full commission is where that can be resolved, and it's where it should be resolved.
Exactly. We have to resolve it. That's our job.
Right.
That's our job. Any other comments or questions on that? Okay, so those are the two little information items I had. Go to director's comments, if we've got no other general comments. For the new members, this is something we kind of put in first time I was chairman, and it really is a good service to the public. Each of the directors has comments. I've tried to restrict them to like 5 bullets and 5 minutes of each of the comments, but they also post them on the internet. So they're on our website. They were just posted last night, but I think and you've got copies this morning. But I think this is for the public's sake, not just our sake. This is fundamentally helpful for people to know what's going on with environmental issues within the division and within the EMC. So, but that said, Vincent's not here doing Demler. So Michael Scott, I'll let you Demler, or whoever's going to do Demler, Richard. Director Rogers, you do Demler, and you want to do water quality right after that, and just get it out of the way?
That will make it a little more efficient.
Okay.
Thank you, Mr. Chairman. Toby, unfortunately, is out west, working on recovery. I think he's attending a resiliency conference where they're talking about resilient methods for future storms, as well as looking at landslides as well. So his comments, I'll briefly go over here. The dam safety section in Demler is engaged in dam safety rules. They're currently on their timeline. They're moving to begin the regulatory impact analysis here in October before we bring it back to the Water Quality Committee, hopefully in March of 2026, and then on to the full EMC in May. The regional office dam safety staff of Fayetteville, this is related to Tropical Storm Chantel, responded to 29 dams because the impact of that storm. 16 of those dams were overtopped during the event with rainfall accumulations of up to 10 inches in 2 to 5 hours. So a whole lot of water in a very short amount of time. One of the dams, the Longleaf Dam in Southern Pines, failed, severely impacting 5 homes downstream and washing 2 vehicles off downstream roads. They were trying to cross floodwaters. Swift water rescue teams were able to save the people in those vehicles. No lives were lost. In the stormwater section, they continue to work with development, IT development of their construction stormwater application permits, and they're looking forward to getting that implemented later this fall. The stormwater section has begun to working on their rulemaking for O2B and O2H rule, and hopefully have the draft work completed and physical note to OSBM by November of this year. That is the Denver report. I'll move on to Division of Water Resources. My report is extremely long. I'm not going to read it, but we did want to provide a summary of the activities related to Hurricane Helene. We are about at that annual year anniversary of that tragic storm. So we provided a little summary of the activity that have been going on from our regional office and the work that we've done out there to provide y'all that summary. There's also updates specific to the wastewater systems and the water treatment plants that we've been tracking, trying to get those back online. It seems to be the same list over and over, but it just takes a long time to get these folks completely back to normal. They're all processing and operating and serving customers. But again, back to normal operations, it will take a longer time. I also want to mention that we have a list of public hearings that we've had, update you on that. I think one of the major grouping of hearings that we are working on are the pipeline hearings. These have taken a whole lot of interest. We got 3 applications in for 401 certification in. We're in the public hearing process and actually finished the public hearing process. The 3 groups that we're working with is Dominion Energy T15 reliability project. We have completed the public hearings and we'll be looking at, we have a deadline of next week where a decision has to be made on that permit. And then also the MVP, which is the Mountain Valley Pipeline. We are completed our public hearing process there. Our deadline for the decision is November 12th. And then finally, the Transco, Transcontinental Pipeline. We are completed with our public hearings there. And we have 11/28/27 when I calculated deadline with regards to that. EPA has also announced a public hearing related to the Asheboro permit, and the decision made it on the Asheboro permit. The details are in my notes there. There's also a link. The public hearing will be on October 22nd. This is dealing with the decision made that there's an objection to the withdrawal of 1,4-dioxane as a parameter in the permit that was issued and mandated. So they are having a public hearing on that. Our drought update is there as usual. We're relatively in good shape. The last thing I'd like to say, and it's already been mentioned, Sue Homewood, a very valued employee of the Division of Water Resources. Chair Keene recognized her, Chair Solomon recognized her earlier. I just want from the division's perspective and department's perspective, thank her for her good work. Yay, Sue. I've been not wanted to admit that she's going to retire, but the time is coming. End of this month, she will be going on to better things. But Sue has been a critical employee for us. Recently, she's been handling the major economic development projects that we do and where we value her most in those areas. She is sage and has been doing a great deal of work training our employees who are currently there and the new employees that come in. So Sue, thank you from the bottom of our hearts here in DWR for your efforts. Those are my comments, Mr. Chair.
Questions of Director Rogers on either front? Okay.
Give a round of applause to Sue.
Good report. Yeah, we give a round of applause to Sue. She'll reappear somewhere. She'll reappear somewhere else, I'm sure. So, Commissioner Smith, anything?
Not a question for Mr. Rogers. One comment, which is in the report, he mentions that the Office of State Budget and Management has approved the regulatory impact analysis for the 1,4-dioxane rule. And that is posted on the OSBM website. I think the links are provided in the report.
Sure.
So I trust that means there will be discussion of that rule in the Water Quality Committee in November, since that is ready for discussion. The other question, this may be a question for the chair, on the IMAX, you mentioned earlier that the IMAX for the PFAS substances expire in October. And the process is for the division to make a recommendation to the EMC on whether to move forward with rulemaking. So are we going to invite a recommendation from the department on those IMAX?
We didn't have the department put it on the agenda for this time, and we didn't have a formal report in the package. Richard and I talked about it. I think that they expire on October 12th. They were done after we had screened the 8 and then elected to do the 3. So the intent would be, without a formal report today or request, that we just, to the spirit of what we did before, we just do the 3 in the rules and let the other 5 expire.
So in effect, the department is not being allowed to make a recommendation.
I wouldn't say not being allowed. It was part of the normal agenda review process. I mean, he can say what he does, but we're not ready to do any kind of vote today, nor has been advertised. So, and I don't think the majority of this commission wants to move forward with IMAX that are higher than the PQL. So, we had already made that determination when we went to public hearing on these rules as a commission. So, the department doesn't have to ask us when they do IMAC adoptions, but they did it and they can expire. So that's the.
And our process provides for the department to make a recommendation with respect to pursuing rulemaking once the IMAC is set to expire. So that's my question.
could.
Apparently, we're sidestepping that.
I'm not sidestepping anything.
Process.
I had an agenda and it wasn't on the agenda. It was just talked about this morning, actually.
Thank you.
You're welcome. Okay. Director Scott.
Thank you, Mr. Chairman. Welcome new members. Waste Management team looks forward to working with you guys. So welcome to the EMC. A couple of quick updates on the rules front. The Rules Review Commission did approve the final determination for the periodic rule review reports for our 15A NCAC O2L, O2N, O2O, and O2P rules related to groundwater and our UST program. So those will be submitted to the General Assembly's APO committee in accordance with the statute. A little more on the PFAS front. We do continue to work with landfill owners and operators. It's been a great collaborative effort, them sampling for PFAS in groundwater, leachate. We've also had some sample soil at facilities for PFAS. We do have an additional round of letters going out. We briefed the groundwater committee pretty extensively on this subject, but we have an additional subset of facilities that will be receiving what we call notices of regulatory requirement, called a NOR, regarding detections of PFAS and necessary next steps to include further assessment and, in some instances, off-site sampling to include private wells. So that work continues. Also on the PFAS front, just to let the commission know, we have some expanded sampling in the Lower Cape Fear region, Brunswick, Columbus, Pender, and New Hanover counties. Comores will be sending out letters this week into next week to about 15,000 additional properties that are eligible for private well sampling related to those impacts from the Bladen County facility. So that's an expanded scope underway as well. Really want to commend the division staff that have been working on the former Pactive Evergreen site in Canton, North Carolina. We have our Brownfields program engaged at that site, looking at redevelopment next steps. Our Superfund program is handling an administrative agreement to facilitate a handoff from EPA related to fuel oil cleanup and black liquor remediation as a result of the paper and pulp manufacturing process. And we also have our inactive hazardous sites program working on necessary next steps of assessment at that site as well. On the Hurricane Helene front, Tropical Storm Helene front, we're really excited about the opportunity to apply for additional federal grants, and some of these grants are starting to come in. We are receiving grant funding from EPA to help address emergency planning and preparedness related to Helene. What's really exciting with some of these grant funds, we have multiple DEQ programs from Waste Management that I work for, Division of Environmental Assistance and Customer Service, and also the Department of Ag. There's a certain amount of money coming in from EPA related to pesticide management, bulk pesticide storage, collection, and management of that material. So we're really excited about those funds starting to come in and necessary next steps to help Western North Carolina. Thank you.
Good. Questions for Director Scott? Good report. Director Abrazinskis. And by the way, make sure you tell the new members how to say your name, because they all said they had some of them said they had difficult names. I said, oh no, we got the guy right here.
I appreciate that, Mr. Chairman. Do a good job of that. Ignore the C and just sound it out. So that's my guidance. But thank you, Mr. Chairman, and good morning to everyone, and welcome to all the new commissioners. Look forward to working with you. So on August 26th, North Carolina celebrated 10 years. That's 3,653 days of being designated as attainment for all of the federal health-based ambient air quality standards. This is a milestone that brings tremendous benefits to public health and our economy. So this streak is really unique. Of the top 15 most populated states, there are 4 states that currently do not have a non-attainment area. Of those 4 states, North Carolina has the longest streak of attainment at 10 years. And so a decade of clean air took decades of work to get there. So I want to congratulate our team, our current and former staff, the commission. Thank you, sharing this accomplishment with us. At the celebration, we discussed some of the key moments and some of the lessons learned and some of the key people, former and current staff and division leaders, shared some of those experiences at the celebration. It was really meaningful for our entire team to see. And so in my written remarks, I included a picture of the last quarter century of folks that have served as division director or deputy director in our division. All right, next topic on to PM 2.5 and exceptional events. The division was notified by EPA last month that EPA intends to concur with the state's exceptional events demonstration showing that Canadian wildfire smoke impacted our regulatory data in 2023. That puts us on a path to receive an attainment designation under the 2024 PM 2.5 annual standard. At the same time, EPA has also announced their intentions to reconsider the 2024 annual PM 2.5 standard, and a proposal is expected this fall, and final actions anticipated in February of 2026. All right, next topic. EPA has proposed repeal of the GHG endangerment finding and associated vehicle emission standards. That was done on July 29th. There is currently a comment period open. The division is reviewing that proposal, preparing comments. The public comment period ends on September 22nd, 2025. And then final note is just a quick update on something we've talked on a couple occasions here regarding the Hurricane Helene recovery efforts and air curtain incinerators. On August 26th, EPA published in the Federal Register an interim final action to provide temporary use for air curtain incinerators subject to commercial and industrial solid waste incinerator regulations during disaster recovery. The temporary use provisions authorize the combustion of non-hazardous vegetative debris from a disaster or an emergency for a limited time without having to meet emission limits or permitting requirements under the Clean Air Act. So EPA's, while they've taken an interim final action, they're still taking comments on this concept until October 10th. This action alleviates the need for the division to seek any further regulatory relief for the larger air curtain incinerators burning non-hazardous vegetative debris from a disaster such as Hurricane Helene. The division is now authorized to provide that permitting relief. This action, however, does not address biochar units, and that the EPA Office of Resource Conservation and Recovery recently considered to not be an air curtain incinerator. Instead, the division continues to pursue regulatory permitting relief through EPA's Office of Enforcement and Compliance Assurance for those biochar units that are being used to process clean vegetative debris in areas declared a federal disaster area. I will say we're having productive discussions with EPA on that, and I'm cautiously optimistic that we'll provide a final update on this topic at our next meeting. In fact, Deputy Director Hartsfield is having a call with EPA this afternoon on this topic. I'll remind everyone that the division is pursuing this permitting relief for ACIs and biochar units because the use of those units is the lower emissions outcome compared to other legal options such as open burning. It's also a safer option from a wildfire risk perspective. So we're trying to enable the lower emitting pathway when it comes to this part of the portfolio of managing vegetative disaster debris in Western North Carolina. That concludes my remarks today, Mr. Chairman. Thank you.
Okay, let me go to, I just want to point out, because the new commissioners may hear Commissioner Yarborough, I know y'all been working on biochar. I'll mess up your background, but Bill's been in soil conservation service up in his county for years, and he's a community activist, and the biochar units have come into him. He's got no financial interest in any of this other than to clean up after the storms and do his other nonprofit jobs and boards and community activity. But do you want to say anything about biochar at all, Commissioner Yarborough?
I just appreciate the help because it is not an incinerator. Obviously, we're trying to protect carbon by being able to restore that. So thank you for being willing to address that and take that as an active thing. Biochar has a lot of opportunities, and hopefully with this new technology, we can make it work.
Welcome. Thanks. Good. Any additional questions for Director Abrazinskis? Again, thank you, all the directors. I know it takes a little time to put this together, but I think it's extremely beneficial. New commissioners, I'd love to get your input about the style of this and what we do, but I think it's, without taking a ton of time when we're usually very tired, there's a good summary for y'all and the public, and then you can follow up. The directors are always very helpful when you talk to them directly at meetings or call them, so that they will follow up on anything with you. So thank the directors for all they do with this. Let's go around the horn and let's start with Commissioner Bailey. We'll go alphabetical order. Any other comments or discussions on today? Anything?
No, just again, welcoming the new members and looking forward to working with you.
Commissioner Baumgartner?
Yes, sir. Thank you, Mr. Chairman. Groundwater and Waste Management Committee yesterday met. We had a presentation information item from DWM on the Bernard Allen Program Overview, which is a groundwater well testing program, and they also provide some remediation efforts in helping when there is detections. Very interesting topic and very much welcome discussion. Other than that, comments I'd say is my 2-year anniversary is today, like many of others. I would like to thank Secretary Wilson and Chief Deputy Nicholson and staff for a much more pleasant year this year. We had a lot of the same topics from previous year before us this year, and it seems like we worked together a lot better this year than we did last year. So thank you that the rhetoric and things have toned down and that we're working together much better. So thank you very much.
Commissioner Chmielewski, welcome.
I enjoyed the discussion today, and just congratulations to the Division of Air Quality on the 10 years of being in attainment. That's huge. And I would like to hear more on a kind of note of concern about the vehicle emission standards, potential changes in the future.
Very good. Mr. Ellison.
Since Commissioner Baumgartner brought up the 2 years, because we were sworn in at the same time, I just don't, I'm at a loss for words.
Commissioner Hardison, welcome.
Thank you. I don't have any other comment or questions.
Good to have you. Commissioner Jaspers.
Yeah, I really learned a lot today and yesterday as well. And yeah, I'm also very interested in, first of all, congratulations on 10 years. And also interested in hearing more about the emission, the vehicle emission, as well as the biochar. So looking forward to that.
Very good. And welcome to you too. Commissioner King.
Well, yes,
not welcome to you, but glad to have you here still, right?
Yes, sir. Thank you. I'm honored to serve. Yesterday at the Water Quality Committee, we had 3 updates. One was on the NCAC O2B and the O2B, the N2 that we discussed yesterday and a little bit this morning, and approved RIA for PFAS in respect to those, and an OSBM approved memo. That was interesting. But that was yesterday, and we voted yesterday. There wasn't an action item. There was a motion on the floor that that we take it up yesterday and that motion failed and, well, just wasn't allowed to be on the table. And, then another motion followed that as a committee and a lot of committee members were here in the audience and saw that yesterday. And, some of you might have not been here, but just to fill you in is that, there was a motion that came on the floor that we on the agenda in November place what we heard yesterday, on as an action item. And that's what we will do. Motion was made and we'll put that on as an action item. So if you look at your attachments that were sent out, the public has those attachments. PowerPoint presentation yesterday was wonderful. That sort of summed up a lot of things. And the RIA approved, OSBM was approved. So we're ready to move forward on that, Mr. Chairman, at our next meeting as an action item. The update on the Helena recovery on those certifications was a really good presentation yesterday. Another good presentation yesterday was the dollars that have come in, the supplemental appropriations on Hurricane Helene. That presentation was a good presentation of the dollars that are supplementing the areas of POTWs and wastewater treatment plants and all the above that have been affected by the hurricane. And I think it was a little over $400 million that we originally looked at and it was released, but I understand there's much more. So we're a good presentation on that, understanding where those dollars will go. In reference to 1.4, we did get an approved RIA from OSBM a week, maybe 10 days ago. And it was 2 or 3 days before me. And I spoke with Director Rogers about 1.4. And with litigation, with the public hearing coming up, the Region 4 has asked for, with 1.4 in the state and where it is on the federal level, we didn't even talk about it yesterday. I felt like as chair that didn't even need to be on the agenda. And I did poll all the committee members the day before and let them know that it had been, but we just weren't going to talk about it because litigation, as Commissioner Smith being an attorney, I did not want to place the committee members in a position that anything that they said being on the committees, in particular, the new ones, the new appointed committee member and those committee members in the audience, knowing that it would go to the EMC full board. I just didn't feel like it needed to be on the agenda, Mr. Chairman. As far as November, we're still, I will get with Director Rogers. We will look at litigation in the state, public hearings on 1.4, anything that's going to be in 1.4. You know, as a part of the triennial review 2 years ago, it came up. 1.4 was an issue. It was laid to bed for a while. The triennial review today, 1.4 may be OSBM just because they approved this committee. This is a commission, and we have to do our homework, and we'll do that in the committee on 1.4, and then it'll be clean when it comes to the EMC. So as far as it being an action item, committee members or commission members, as far as it being an action item in November, I'm not sure. I can't give you that answer now, but it will be on the agenda in some form or fashion in November. Thank you, Mr. Chairman.
Any other comments?
No, sir.
Okay. Commissioner Gibson, you got a promotion today. I don't know if you noticed it. I was going to elevate you all the way to Chair of Civil Remissions too. But there is a meeting.
Vice Chair.
You're Vice Chair,
It
so you have
seems
to
it's been
assume it.
canceled.
Oh, it has
so,
been canceled? I didn't.
Yes. Late breaking
Okay,
cancellations.
well,
so,
very good. So
yeah,
you're
thank you.
reprieved, but you look like you'll get a promotion soon.
Okay.
So, Commissioner Gibson, comments?
No comments other than just, again, it's a privilege to serve in this role. And I wanted to thank DEQ for all of the hard work that you guys do and all of your dedication. And thank the other commissioners as well.
Commissioner Zavaleta.
Yeah, I know, it's a mouthful. No, again, this has been great to be here for the past couple of days. Having experience at the federal rulemaking level, it's really interesting to see the similarities and differences at the state rulemaking level. So I do have a great appreciation for all of the work at DEQ that you do and look forward to diving in deeper. Thank you.
Okay, Commissioner Smith.
Well, I guess first I want to reassure Commissioner Keen that I certainly have no concern about moving forward with discussion of the 1,4-dioxane rule simply because there is a challenge to the Ashboro permit. Those are two entirely separate issues. The basis for the Ashboro permit limit was not a rule, since we have not adopted, not a specific water quality standard, so since we have not yet adopted one. So I don't see any conflict between the committee moving forward with discussion of that issue simply because there is an individual permit appeal that is not an appeal exactly, but a permit issue that is ongoing. Having said that, I was again disappointed yesterday at the lack of action on the PFAS surface water rule. The regulatory impact analysis on that set of rules was available 2 weeks before the July meeting. And yet there was not even discussion of that draft rule in July. We seem to be finding multiple reasons not to talk about 1,4-dioxane and the PFAS surface water standards, which is disappointing. I hope the vote in committee yesterday means that in fact there will be action in the Water Quality Committee in November on the surface water rules. That would be a welcome step forward.
Yeah. And as I mentioned before, on the PFAS, I pushed very hard as the chair of this commission to get that to a vote of the full commission by March and May, and we didn't get there for numerous reasons we won't go into, but it was my intention to have the old commission vote on that as quickly as possible. When we got the OSBM thing, we not reviewed it before the July meeting, but we always had commissioners missing. And some of those commissioners were people I thought would be for it, or really thought I would be opposed it, and we needed to have the debate. And so we're just having new commissioners in yesterday when Commissioner King did not want to put it on the agenda. I said the full EMC is not ready for that debate until these commissioners have got their seats and kind of understand the issue better. So I did not disagree with the chair on that at all, the committee chair. But I did, for the record, we have pushed to have that done in March and May and didn't make it. I think we are equipped now with our committee members in place to start moving some other things forward. And, but we do have to look at the 1,4-dioxane physical note because we have not really had time to even read it yet. So, but all good comments and commitment to continue to move in PFAS and 1,4 forward. Okay, Commissioner, did you talk about water allocation? I missed you.
No, the Water Allocation Committee had a couple of information items, one of which was on just an update on the interbasin transfer proposals, and the other was on the flood mitigation program, the new tool that's being developed to identify flood-prone areas and mitigation efforts.
Okay, so I'll segue to Commissioner Tweedy to say congratulations. You're the hearing officer for that IBT. And for all the folks that are new, I will try to break you in on some very easy hearing officer activities before you get an IBT. But Commissioner Tweedy has much experience and 2 years on the saddle now, so you get the IBT EIS, Commissioner Tweedy. Congratulations.
Thanks, sir. Well, once it gets around to this part of the horseshoe, pretty much everything's been said. So I'll just say, again, welcome to the new commissioners. Look forward to working with you, and continued thanks to the department staff.
Jared?
I will echo Commissioner Keen's sentiments that the presentations yesterday during committees were great by staff. Those are much appreciated, and we appreciate the effort put into those. A lot of information was conveyed, and it was conveyed very well. So again, thank you. Looking forward to the flood blueprint development. Of course, that originated in the watersheds and the river basins that are in the eastern part of the state. And I want to see how that translates and moves west. I'm very interested and passionate about that. As Commissioner Yarborough, we're Western guys. So obviously we're representing the state, but we also want to see development and hope it doesn't take a long time for those tools to be implemented in the western part of the state. Thanks.
Mr. Yarborough.
Yeah, I appreciate the opportunity to speak here just a minute. I just want to thank the staff for what they've done with this 401, 404 general certification. That is a big, huge thing to recovery after a hurricane. That the public comment period, I understand, is now. I asked yesterday in the water quality piece after your presentation if the EMC would consider joining with the department about public comments, because this is going to be big. It's through the Army Corps. We need this when we have an emergency. To me, an emergency doesn't say 90 days. It doesn't say 180 days. Emergency is till the work's done or the money runs out. So we need those kind of comments, and I would appreciate what you've done on that. The piece for the new folks, we're just glad that you're here and glad you don't have to do what we did. It was Tim brought it up, Commissioner Baumgartner. 2 years ago, as soon as we walked in, we were involved in 2 lawsuits and a bunch of other stuff, and the cooperation was very difficult. But now I think everything has come together, and it almost reminds me of what the definition of a scissors. There's 2 pieces to a scissor, and it takes both of them to work. You never heard of say, I'm going to use a scissor. So I think both of us, so now we have the opportunity to work with DEQ and a commission and be able to make something happen. And that's what I'm really excited about. And I think things have changed, in my opinion, for the good. So we appreciate what you're doing, or I certainly do.
Mr. Reardon, hard act to follow.
How can I touch that with the scissors, right? But he has a lot of those mountain sayings up there, and they're all good ones. I've heard a lot of them over the last 20 years. But no, it's exciting to have the new membership here. I really like this morning hearing some of the bios and the diversity of the new members that we have. I think we got a really strong group. I really do appreciate the new decorum by the department. Don't anticipate many press releases or other statements out there today that we've seen in the past, but we really appreciate the new leadership and what we can do collectively. Everyone on this commission takes the responsibility and the duty of protecting the citizens of this state to the highest level, and we're going to keep that commitment and do this in a very sound way. So all my comments. Thank you, everybody.
Very good. Thank you, Vice Chair. Counselor Young. Ford, anything?
I just want to echo the welcome to all the new members. Very excited to work with you all. That's all I have. Thanks.
Okay, that was simple. A couple things, and segueing off of her into an old guy named Philip Reynolds that's still around, but he's at the AG's office that used to do this for us. He's talking about quasi-legislative and quasi-judicial. So I'll segue out of this whole thing today, marching orders to you guys or some comments. Most of what we do is quasi-legislative, which is rulemaking. And the simple way I put the legislative part is you can talk to anybody about anything at any time for rulemaking in your quasi-legislative function. And you will. You're going to get emails and phone calls from people you've never known and people's third cousins and people that'll hate you on both ends and people that may moderately hate you in the middle, but it'll be rewarding, but it'll be painful sometimes. But you are free and you should talk and gather information. You've been appointed here for a reason, and in your quasi-legislative role, there's no reason you can't do that. Now, I will say this, respect your fellow commissioners, because we can't do anything without a body, and no one here can speak on behalf of this body. So as you gather information or be nice to people when you talk to them, you really can't make any decisions or come out and say, guarantee anybody we're going to do anything, because it comes down to the votes of this full commission. And it's got to be at least 8 of the 15 that make anything happen. So I just remind you there is another class, and Councilor Young will remind me, some of the things we do are quasi-judicial, and that's finding a fact. And some of you, like Commissioner Keene, goes into quasi-judicial when you were chairman of the Wayne County Commissioners for special use permits, but it's the same here. There you're acting more like a judge or a jury, right? So you cannot discuss things that are quasi-judicial outside this body or have any discussion of finding a fact before we debate that as a body. Those things are things like declaratory rulings. DEQ enforces, we make the rules, DEQ enforces the rules. If someone is aggrieved, Mr. Hardison may have done this, they can come to us and appeal DEQ's rulings in a declaratory ruling and say, were they out of line? You adopted the rule, was what they did the right thing to do. We had one of those in air quality a few years ago, where we had a department was regulating something by a mass, and the rule said it was by concentration. It wasn't that the EMC didn't want to regulate it by concentration, but that's not what the rule said. The rule said we want to do it by mass, not by concentration, but we had to rule against the department and then we change the rule. Okay, but that's what a declaratory ruling is. But those are finding of facts, as are these IBT certificates. They are findings of fact. So those will work with counsel on those, but be very careful on the quasi judicial. Most of that is, you'll know it's coming because council's going to warn us of that. But I just say there's two classes, and sometimes we can talk to people and sometimes we really just need to stay quiet. So use your judgment. In that regard, we did get state emails last year, and some of you guys, new ones, have been through that process. It used to be we had to give our personal emails in. So all this communication from all these groups and all these letters came to our personal email. And when we got petitioned or request for public information or anything to do with legal stuff, you had to bring your whole computer in and do your own personal emails. We did that for years of this commission. We finally worked last year to get that to be on the state system because DEQ is the official keeper of our records. And so that's where it belongs. So use your DEQ email addresses for all your business. If somebody emails you on personal address, copy yourself back or copy counsel or somebody to make sure we get it in the DEQ email so that we can get everybody focused there and you don't have to open up your personal accounts where you shouldn't be doing EMC business anyway. So use those accounts. And just so a reminder of your texts are also in part of that. So if you've been subpoenaed or get involved in one of these lawsuits, you'll have your text looked at as well. So just be careful of how you handle your text as well as your email as far as the business goes. Last thing I'll say is in talking with each other, and this is a body. We're supposed to be a body. We're supposed to be a team of commissioners. Discussion is okay. Deliberation is not. We can't decide things before we come into a meeting. That's violating public meeting law. So if you need more information or some of you talk to each other and say, I'd really like to hear from this, there's probably nothing wrong with that. But when you start saying, I'm not going to vote for something, or I'm only going to vote for some of this, you've kind of crossed the line. You've gone into deliberation. So just be careful. As a rule, we don't have a lot of responses to emails. Commissioners will send emails to each other. We can't get into multi-tiered layers of email because now we look like we're debating or deliberating something. And again, we're violating public meeting laws. So I just say be careful. Use your DQ email addresses now. Understand that it's okay to talk to people in most cases, but in some cases, you really just need to keep quiet and be aware if we're deliberating things, we're violating public meeting laws. So just be careful with how much detail you go in with each other. As always, call Ellie. You've got her number. You've got her stuff. Call her. Use me as the conduit. I'm not going to try to answer it all on my own. I'm going to try to probably just kick it right to her, but at least I can be the focal point where if anything happens to anybody, people aren't accused of debating on their own. Some of this is repetitive to many of you because you've served on boards and commissions, public boards and commissions. So, but to others, it's not. And I think it's a good reminder to everybody. Last thing I'll say is I apologize. Commissioner Deerhake sent me that a former member who some of y'all may know, the former mayor of Chapel Hill used to be on this commission. He did pass, and I will have his name for you next time, but it's bad. I do like to recognize former members if something happens or they're involved in the debate or if they pass, unfortunately. So I just can't put my fingers on that email right now. Commissioner Bumgarner.
Just to add on to the email, we do have access to OneDrive as well. So as we're saving files, if you save them to that OneDrive, it's all in the cloud, and DEQ can query all that when there's a public information request. So you don't have to take files from your personal computer and send it to DEQ. It's on the OneDrive. They can pull those off. So that's another added benefit we have with the email.
Mr. Elson.
But it still helps to keep Ellie's number on speed dial.
Well, you especially, it helps to keep her on speed dial, right? Anything you want to add to any of that? I just thought I would give some general stuff out. We'll cover more to orientation, but is that?
I was gonna say, we can cover open meetings and public records requests at opens or at orientation, but I think for now, just be aware that anything that you write down is related to commission business is subject to a public records request and can be sent out.
Do we have a date yet for orientation?
No, I need to get all y'all seated first and then look at some dates on the calendar, but I do think it will be November or December before we would try to do something. Okay. All right, hearing no other comments, we're dismissed for the day. Thank you, guys.
Having another committee meeting?